item number 1.
Yes, Mr. Mahapatra, we have been referring to that judgment of the Honorable Supreme Court. If you want the reference, you can just see and note it. Hey. Packet ta diyo. Pura ta so buda packet kholo ni kiche. Packet kholla ki ani kiti. Bandhi bodu chunti kahi.
Lock kari bandhi roko. These are to be mentioned, not delivery of judgment.
Packet ta mote badhantu pura. Potash.
ଆପଣ ମାନେ କଣ judgment ki dekhi nahanti?
No, sir. Sorry, madam.
But it is strange. You are all doing electricity matters. A judgment was pronounced in the last week of April. 2 weeks have passed. And Supreme Court judgment.
Right.
A lawyer should be always alert to see what is this development in Supreme Court. ଆମେ ପ୍ରତିଦିନ 50ଟା 100ଟା କେସ୍ କରିବୁ ତଥାପି ଆମେ ଆଲର୍ଟ ରହୁଛୁ ଆପଣ ମାନେ ଯୋଡା 3ଟା କେସ୍ ଦିନକୁ କରିବେ ତଥାପି ଆପଣ ମାନଙ୍କୁ ଟାଇମ ହଉନି.
This is the last one.
No, and this judgment has been referred by us twice or thrice. For last 8 days we are referring this judgment. What message is going to the public? Now we are all in live streaming.
I'm sorry for the internet. I am pardon that I am next occasion.
So in your case, there is concurrent finding of fact of the GRF, Ombudsman, and also in the review petition.
My lord.
So, in fact, we are closing all the matters because I think others. No, where are the others? Second matter, Mr. Das. Fourth matter, Mr. Tripathi. Just you please take note of that. Take a print and.
Yes, there is a concurrent finding. If there is a concurrent finding,
there are two aspects: concurrent finding of fact, well established earlier judgments. Second aspect, expert on the subject. The Supreme Court says that after the OERC, AFTEL, whether they can reopen the factual aspect. That is one aspect. From my lord, because my lord, being the senior most, also he referred to that decision. In fact, prior to me, he has referred to decision. Yes. Third thing is that technical issue. Same line that factual section 100 that also second appeal principles. Also, as the appeal before the Supreme Court. Supreme Court says that we cannot reopen it. The issue is very specific and it has been well established. Fourth thing also that epilogue you please read. That the Supreme Court has expressed concern that in this, you have been, all the discoms are busy in litigating, the cost is added to the cost of the electricity. only with a purpose not to implement the order because they are statutory body. They are basically toothless. They don't have a mechanism. And in one case, you have taken a stand before the GRF. In one case, I don't know who. I'm not. Please don't take it. But you means doesn't mean Mr. Das or Mr. Tripathi. That ombudsman order is not implementable. So if it is not implementable, can you take a stand before GRF? So these kind of stands have been taken also. So all these four aspects. So that has been, so since we have been referring to, so we thought it better so that it can come and we can have a interaction with you. So that is the purpose.
Okay, we close all these matters for judgment. Huh? Further hearing made. Further hearing made in the involvement of counsel for both sides, individual order. Okay, matter reserved for judgment.
Item 3 is also covered, Miller. Item 3 is also covered.
Yes.
Item 3, it is also covered.
You raised that point.
Miller.
Whether High Court can reopen the
Miller.
whether they have produced anything before the learned forums below to support their argument regarding that fixed that tariff orders, whether applicability and all that. You have raised that point. In fact, one submission is enough to take care of it.
I am grateful, Miller. Thank you.
For their raising some doubt in view of the Honorable Appeals Court and clarification sought for keeping in view the judgment of the Honorable Appeals Court in Civil Appeal 11095/2018 appears to have been pronounced after the matters were reserved. Pronounced on 20th April 2023 after the matter was reserved for judgment. The matter was brought for to be mentioned. In the further argument, the court had the submissions of the respective counsels. Further hearing concluded. Matter reserved for judgment. Now, oh, so that's time.
For orders, item 7.
Matter.
Item 7, we have no instruction. We have no instruction.
Item 7.
Miller, pardon me, item 5, Miller.
5 all covered.
No,
You have to say anything.
Miller, 5, item 5, issue is something different. There was a year-old case.
Sir, you can't re-argue the matter now. The difficulty is that
On the decision aspect, that's all.
Miller, that is not covered by that.
You say this case is
because
not.
Miller, the Honorable High Court dismissed the writ petition, granting liberty to approach the GRF.
Sir, we are not, sir.
And Miller,
you had argued the matter at length. Yes.
So
yes, all your points have been taken note of.
जो issue involved थिला initial writ petition रे ते तला गले नुआ issue नहीं
That we have already understood. We have taken note of all those things. Only on the aspect of the coverage of the judgment
So maybe you were a little bit late. So we had discussed all those four aspects. Mr. Mahapatra was there, Mr. Tripathi, and I don't know whether Mr. Rai was there. He was also late, maybe.
Yes. Yes, sir. Mr. Das, you want to say anything on the judgment?
I have not gone through that.
Okay, all right.
Very good.
All very good.
Ignorance is always bliss.
Mr. Rai, do you have any submission on the judgment, recent judgment of the Supreme Court?
I have not gone.
Huh?
I have not gone through.
Oh, yeah. Right, very well. Thank you very much. Thank you very much. Stay away from these update judgments, better for the society. Yes. Yes, item 7.
My lord, item 7, I have no instruction. My lord.
No instruction,
Fine.
counsel. Please file a memo.
My lord, I have.
Counsel and counsel appearing for the petitioner submits he has no instruction from the client and doesn't want to pursue the matter. The matter stand dismissed. Memo so filed, be kept on record. Matter stand dismissed for no instruction.
Item 8,
Item 8, my lord, your lordship may kindly see the last order. All through, my lord, it was heard by the Honorable Single Judge. And the last order was 29/7/2019, my lord.
You are consumer,
Yes, my lord.
so
That is the,
you have power. You are for OP number 1,
I am for the petitioner.
petitioner.
Yes, my name has been.
TK Misra has been shown as OP.
My
1.
lord, wrongly.
All right, you are for petitioner,
I am for the-
substituted counsel.
Yes, ma'am.
Okay,
After my lord and senior expired. ma'am.
then yes, what is the challenge here?
Here, my lord, only limited grievance. Change of name. Lordship may kindly see the prayer. I have approached the GRF. GRF are allowed. Subsequent page 24 of the brief, my lord. The complaint petition is allowed.
Your dispute was only to rectify the name of
My
consumer
lord,
and GRF has allowed that.
allowed that at page 24.
So what was the ground of changing the name?
Changing, my lord, I have applied the electricity after the
Don't say I, who has applied?
petitioner. has applied.
Oh, petitioner, who is the petitioner?
Here is Muraldhara Pati.
So please refer to the name because there is a confusion in the name.
Sorry, sir.
And your request was changing the name.
Yes,
So Mayadhara, who has applied?
Muraldhara Pati.
Murlidhar. Murlidhar applied,
my
right?
lord. They have installed the
Agreement
meter.
kaun alla?
They have installed the meter, but bill has been given in the name of
Agreement, agreement.
No.
Kindly respond to the query.
There must be entering into agreement.
Agreement
Yes,
on Tila.
Yes, yes. That is at page 16 of the brief, my lord. Muraldhara Pati.
Page 16.
My lord.
Page 16 is not the agreement.
That is the order issued. That is the Muraldhara Pati. In the name of and address Muraldhara Pati.
So
They will say Tulsi Put.
have you enclosed your application
I have
for
not
supply?
application, that is only the notice form 16 at page annexure 3. at
You
page
have
16.
filed document annexure 1 and 2 showing that Murlidhar is the owner.
Yes, ma'am.
Okay.
Agreement of.
Then the annexure 3 also in the name of Murlidhar.
Muraldhara.
Murlidhar. Then how do you find that it is in the other name?
That is in the bill, my lord, your lordship may kindly see.
Bill annexure 4, it is also
Yes,
Murlidhar.
Muraldhara.
Murlidhar.
But they are giving the bills in the, there is 2 meter, there is 2 meter. One is Muraldhar and another is Mayadhar. They have given the earlier installation at the Mayadhar.
Where is the cause of action? So
I filed before the GRF. But GRF has allowed it for correction. And to give a fresh
Oh, don't
service
trans-
connection,
don't jump.
my
You
lord.
don't find the chronology. where is that bill raised in the name of Mayadhar? So that you have a cause of action to go to GRA.
That has not been filed. That bill has not been
Because
filed.
5, 6, all appears to be in the
All
name of
Muralidhar.
4, 5. In the name of Muralidhar.
Muralidhar.
In the name of Muralidhar.
My lord.
And 6 also in the name of Muralidhar.
Muralidhar.
So what is the cause of action to go to DRA?
GRA, because my lord, they are given two bills. One is in the name of,
Where is that? Don't argue on air.
yes, my lord. That bill has not been annexed, my lord.
Then how, where is the foundation to for our at least understanding?
We'll give with an
You will
affidavit
give-
of that.
No, we'll dismiss on that account.
My lord, the GRF has allowed the same.
Maybe, but we don't find any foundation.
And so far the ombudsman is concerned. my
Okay,
lord,
now come to at least GRF recording your case.
yes, my lord.
Has he referred to bill in the name of other name?
My lord. Your lordship, the petitioner has submitted that he has applied the rectification of consumer in monthly electric bill number, consumer number so and so, which is wrongly printed as
Okay,
Mayadhar.
who went to ombudsman?
I have come,
Why? If
Mural,
it is
because-
allowed?
because in the bill has been come in the name of Mayadhar Pati.
After that,
Yes, that's
so after that, if a bill has come in the name still in the wrong name,
my lord.
where is that bill living?
I have not filed that. That
So
is,
whose responsibility? So we dismiss, we don't find any trace to your argument.
and basing upon the documents, my lord, that the GRF has allowed the same.
Absolutely, we don't find any trace. There is no connectivity.
Kindly see the respondents person. OP has submitted the service connection bearing
No,
consumer.
no, we
number
can't
so
go to that
made in the
extent.
name of
You
Mayadhar
can't go to that extent.
and only
You
limited.
withdraw this. We don't find any foundation.
That is bills, 2 meter has been installed. That is the whole.
Are babu, sabu katha thik achi. We'll go to the foundation or not.
My lord.
You have no foundation sustaining here.
May pray only one additional affidavit will file that disclosing the bills.
No,
including
that
the
can
bills.
come in an additional affidavit. That can't come. This is application in 2018.
Yes, my lord.
You have
That
to
has
make
been-
out your case in proper sense.
That has been allowed the GRF and ombudsman
It's
also. allowed.
allowed. We find it is allowed by the ombudsman. Therefore, there is no reason for your going. Then you say
Still-
thereafter also even the wrong bills came. If wrong
Yes.
bill came, you could have gone for execution. GRF order can be executed. What was the necessity of going to ombudsman? It's a fresh cause of action then. Or action contrary to the GRF direction. Then what is the course available?
My lord.
Execution course is available very much.
My honest friends, senior friends have left of something. The complaint person allowed, but there is a OP is direct to provide fresh service connection in petitioner. Demand provide all areas so that he come to the ombudsman. My lord.
Huh?
All area dues on the existing lines are cleared.
Hmm.
So that he come to my lord, the ombudsman and ombudsman of same grievance, my lord. So that the constitution,
So he was agreed by the second part.
my lord.
OP is directed to provide a fresh connection to the petitioner on his demand, provided all areas due. So
Yes,
there is no illegality. There is no illegality. If there were areas,
Yes, sir.
Area
that-
has been paid, my lord.
huh,
Area has been cleared.
cleared. Let us see Mr. Misra, unfortunately, all your submissions on air.
Your lordship is correct because the.
What is this filing? You
complaint
say something which is not on record. 1, 2, 3 stages.
Fact remains.
You
my
must
lord.
have pleaded that in your consumer application.
Yes,
Where is the consumer application here?
that has not been.
To at least have a trace. So what has been filed?
filed
nothing.
because.
There are
The,
serious flaws in as much as
may I pray one thing, my lord?
neither there
Permitted
is
to-
filing of
Permitted to withdraw
bills
to file a better application, my lord. If the
indicating
cause of action arises.
withdraw karibe.
Oh.
Yes, okay, in the
Cause of action
hearing,
arises.
okay, this court found series of difficulties in as much as in absence of filing of bills to establish the case of the consumer prior to GRF proceeding, and if at all there was mistake continued after the GRF order, further bills, at least to establish that the authority still went on indicating the wrong consumer name. There is no filing of the consumer application even, at least to find a trace to the allegation before the consumer, before the ombudsman. It is finding difficulty in placing his case. Sri Mishra, learned counsel appearing for the petitioner, wants to withdraw the writ application, however, with a liberty in the event any cause of action surviving to move further. Okay, writ petition stand dismissed or permitted to be withdrawn, however, permitting the petitioner to bring further application in the event any cause of action still survives.
I am for the opposite party, my lord. I am for the
Yes,
opposite.
Mr. Nath, Nath, you are for the licensee,
Yes, my lord. I am for
electricity
the.
department.
Yes, my lord.
Okay. ना लिख दो
Item 9
मिस्टर नाथ आपन को ना इधर कहीं उठी नहीं
ଅଛି, please.
BK Naik ପରେ ଉଠିଛି। Sorry, my
हाँ
lord.
बीके नहीं को पर अच्छी
BK Naik, my lord.
राइट नहीं yes 9
May it please your lordship. My lord said, if you see
ठीक
the
है be
order-
on mic please be on mic
if my lord sees the order dated 25/4/23, the IE has been filed for modification of the order.
order dated
25/4/2023.
25/4 yes
My lord, here on the last but one line, and that GRF before the ombudsman 2, it will be ombudsman 1, my lord.
last line para
Paragraph number 2, last but one line.
yes
It will be ombudsman 1, my lord.
it will be ombudsman 1
Yes, ma'am.
okay that's the correction you have sought for
Yes, ma'am. And the next page,
okay this is the application for modification of the typographical error in the order of this court dated in para 2 in the order of this court dated 25/4/23
and in para 3 also, my lord.
Para
In para 3
3
also.
as well as para 3 Hala. In as much requesting for correction of ombudsman 2 wherever appearing to be read to be corrected as ombudsman 1 okay mistake stand allowed by bringing in ombudsman 2 as ombudsman 1 wherever it appears in the order dated 25/4/24. With this observation, the mistake stand disposed.
Obliged.
Yes.
For addition, item 10. My lord, item 10.
Lordship, in item 10, we have filed a memo, not pressed your lordship.
It's all right. A memo has been filed for not pressing the writ application.
Lordships, due to the stay of this, Lordships, the matter was stayed since 2016 before the Labour Court, Jaipur.
It is not pressing.
So, but the
What
period,
more submission is necessary? We are dismissing the writ petition.
Interim order stand vacated.
If you have
Obviously,
any
it
cause
will
of
merge
action,
with the
go ahead,
final
Abel. Your prayer cannot be allowed here.
yes, Lord.
Yes, memo so file be kept on record, matter stand dismissed as withdrawn with vacation of interim order. Interim order thila, interim order dated 16/2/16. Yes.
Much obliged.
Item 11.
Item 11, my lord, I have filed a fresh booklet number.
Mass kadiga,
Item 11, I have filed a fresh booklet number,
press wakalat na file ko.
including Mr. Sudeep Kumar Sodhik.
Kaha pai vo? Kaha pai?
Again,
Kaha pai vokalat na file କରୁଛନ୍ତି?
fresh କରୁଛି ମୋର ନାଁଟା ନଥିଲେ ତ
ଆରେ ବାବୁ
Petition
ପିଟିସନ
ପାଇଁ,
ପାଇଁ ନା
petition.
ଅପୋଜିଟ ପାର୍ଟି ପାଇଁ
petition.
ପିଟିସନ ସେଟା କହିବେନି
My lord,
okay there is fresh wakalatnama filed on behalf of the petitioner through so and so and associates fresh appearance be kept on record. Yes, Argu.
Yes, my lord.
Argu, what is the issue here? Registry directed to regularize the appearance aspect. Yes, Argu.
My lord, my lord. The order of labor code is on challenge, my lord.
It was heard earlier, na?
Yes, my lord.
You had no power, therefore it was adjourned.
My lord.
Hmm.
The petitioner has worked for more than 24 days, my lord. 224 days. He was refused employment with effect from 1/5/2007 without the due police procedure of law under ID Act, my lord.
Hmm.
The conciliation having been failed, he approached before the labor court pursuant to the reference sent by the labor department. After appreciation of the evidence and hearing, parties had held that
He approached the industrial tribunal or labor court? Or
labor court,
a reference was made.
reference was made, my lord.
So please correct your language.
Yes, sir.
There is also a procedure for approaching directly to the labor court or industrial tribunal because of the amendment.
Yes, my lord.
Therefore, there is a difference between these two statements.
Yes,
It's a 10-2 reference.
my lord.
So conciliation failed.
Yes,
Accordingly, a reference was made to the
labor court.
Now there is industrial adjudication. Yes, so
My lord, the fact is, my lord, I have a file a date chart, my lord. For my lord's appreciation, that date chart is very essential. Up to 9/5/2007, it is essential, my lord. So maybe permit to
you are sure your date chart is in consonance with your statement of claim?
Yes, my lord.
You are sure?
Yes.
Then give it.
My lord, I have already given my last occasion, including the two judgments with a memo.
Yes.
My lord. On 24/12/5, opposite party state labor institute published a notification for appointment of a clerk, chowkidar cum peon on contingent basis.
Where is your written statement of claim?
My literally, I have given a memo, my lord.
That
Last occasion, I have given a memo.
You have filed along with memo?
Yes, my lord.
Statement of claim?
Yes, my lord. Statement of claim.
Statement of claim you have filed with a memo?
My lord. Last date, my lord.
Where is that, Oxy? Where is that?
I have already filed my last day.
No, you have filed, we don't find here.
ଆପଣଙ୍କର ରିଟ୍ରେସିଭ ପ୍ରିଡିଂସ୍ ଟା ନାହିଁ
ଲିଟରେ ପ୍ରିଡିଂସ୍ ଅଛି
କୋଉ ଆନେକ୍ସ
ଏଥିରେ ଆଜ୍ଞା ମୁଁ ମେମୋଟା ଅଛି ଆଜ୍ଞା ମୁଁ ପଢି ଦଉଛି
ରିଟ୍ରେ କୋଉ ଆନେକ୍ସ କୋଉ ପେଜ ଆପଣ ଇଣ୍ଡଷ୍ଟ୍ରିଆଲ ଟ୍ରାଇବ୍ୟୁନାଲ ର ପ୍ରୋସିଡିଂ ଯାହା ଆପଣଙ୍କ ଫାଇଲ କରିଥିଲେ ତାଙ୍କ ରିପ୍ଲାଇ WS ସବୁ ଅଛି କୋଉ ପେଜ
It is always based on a statement of claim by the workman and supported by a written statement by the manager. So statement of claim କାହିଁ ଆପଣଙ୍କର
ମୁଁ ଆଜ୍ଞା ଦେଇଥିଲି ଲାଷ୍ଟ ଅକେଜନ मेमो संगरे
oh we don't find it here
मतलब मैं relevant portion I am reading my lord
sir मिलिबा दरकार sir
you are reading
मिलिबा दरकार
that out again
physically available in the records
LCR আসছে কি
yes lord
LCR com
দেখেল LCR এটা LCR statement of claim. The statement of claim first
my statement of claim on dated 28/1/2015
report
the place dates are you now place the date chart
my lord my lord 24/12/5 notification was published
yes please
my lord 2/1/2006 petition was selected and he was called upon to work for 24 hours for a day against payment of 100-500 per month. It is very important, my lord. Since then, the litigation started.
Yes, next.
Then 15/11/2006, After continuation, I have given a representation before the commissioner, come secretary, come chairman, State Labour Institute. The opposite party.
1511.
15/11/2006, my lord.
Okay. 1511, where do you find that in your statement of claim?
My lord.
1511, where do you find that in your statement of claim?
No, it was the lower court lawyer.
Therefore, we very in the at the very first instance,
My
we
lord.
said your date of events must tally with your statement of claim.
My lord, exhibit is there, my lord.
Please,
My lord.
we outright reject this. We outright reject this because this is not in consonance with your statement of claim. You can't put anything here. This is trial over. This is trial over.
My lord.
We are almost in appeal stage.
My lord, and my lord.
So therefore, please ignore your events of.
My lord, your lordship kindly come to the finding of the labor court in the judgment, my lord. Two issues, my lord, rise.
Nothing is there and everything will be now introduced.
My prayer was before the labor court was, my lord, that I have been retrenched without doing procedure of law, my lord, labor court at the Industrial Tribunal Act.
So therefore it has to go by the reference. What was the reference?
Reference, my lord, page 21 of my writ petition.
Please read the reference.
Whether the action of the management of State Labour Institute, Bhubaneswar, in the terminating the service of the Biswanath Rath, Chowkidar cum peon, with effect from 1/5/2007 is legal and was justified. If not, what reliefs Meher is entitled to, my lord?
So therefore, that was the reference.
Reference, my lord.
Now
And
yes,
that reference is reflected in my claim
your
statement.
ground of challenge to the award. It has been dismissed against you.
My lord. It was gone against me, my lord.
Yes.
On
So
the
what
ground
is
that
of your dissatisfaction.
not my lord. On the ground that State Labour Institute is not coming under the ID Act, that held by the tribunal, my lord. Though it is not correct. That I will satisfy, my
No,
lord.
this has been dismissed on the ground of
That the
institution is not coming under the definition of industry.
2J of the ID Act.
2J of the
ID
ID
Act,
Act.
my lord.
Right.
If your lordships,
Not an industry.
not an industry,
So
you concluded the labor.
all right.
On
So
the-
that must be an issue to that effect.
That is two issues.
What is that issue?
That issue, my lord. One first issue, my lord. Issue is, my lord,
So issue
whether the
number
opposite
one is
party,
accordingly phrased.
my lord, issue is reflected in order sheet page 23 of the writ petition,
Yes, page 23.
my lord. Issue, may I place, my lord, the issue? Whether the organization of the first party management is in the industry as defined under section 2 of the ID Act. Number one issue. Number two, it's at page 24, my lord.
Number two, not relevant.
My lord, my lord. Yes, my lord.
If you succeed on issue number one
My lord.
in reversing the award,
Hmm.
then it has to go back for deciding on 2 and 3.
My lord. Straightway, your lordship kindly come to 25 of the issues, the finding of the labor court. May permit to read, my lord.
No, read para 5 whole
My
on
lord.
issue number 1.
It is admitted the fact payment first party management that the second party was engaged with Chowkidar cum peon on contingent basis.
1 minute. Documentary letter. You are a chowkidar.
My lord. Peon cum Chowkidar, my lord. I was working, my lord, what my conscience of my lords here. So why I am submitting, my lord. I was working, I was engaged for the 24 days, 24 hours of working, my lord. I gave it the representation. That's the issue started, my lord. They have relaxed my working hour. Then after 1 year, then they have terminated. This is the issue, my lord. And that 2 days, 2 points, my lord, that
Don't argue on merit because merit has not been
Yes,
gone
yes,
into
ma'am.
by labor.
I will, I am coming.
So
I am,
it is decided only on the jurisdictional aspect.
Yes,
It
ma'am.
is not coming under the 2J.
Right.
Therefore, no industrial dispute lies. You may have dispute elsewhere.
my lord.
There is no bar.
But my
So therefore, first satisfy that this institution is an
Yes, my lord.
industry.
Yes, my lord.
So to
May I
that
permit to
what
read,
is
my
your
lord?
submission.
My lord, may I permit to read?
Yeah.
That aspect is reflected in the order sheet. what the Honorable Court will has held, my lord. I am permitted to read, my lord. It is submitted by the first party management. The second party was engaged as a Chowkidar cum peon on contingent basis in the state level institute by the auditor so and so with a monthly honorarium of 1,500, but challenged the maintainability of the present proceeding before this court on the ground that the organization of the first party management is not coming under the definition of industry as defined under section 2J of the ID Act. The deputy director of the first party management, who has been examined as a MW1 at paragraph 3 of his evidence, disposed that the Institute of the First Party is a state government sponsored autonomous body registered under Society Registration Act, my lord, and a premier institute of Orissa as well as the country, which is created by Labor and Employment, presently ESI Department of Government of Orissa, by the resolution number 4321, letter so and so. At paragraph 4, his evidence he has deposed that as per the General Council meeting, the State Labor Institute Orissa has held on 21/12/94 under the chairmanship of Honorable Minister Labor and Employment Department, Government of Orissa, and it adopted the resolution by accepting the rules and regulation of the State Labor Institute, which was adopted by so and so dated. It was clear from the evidence, very important, my lord, that the object of the institute are initiate and promote professional activities in the field of labor related matters, and conformity with the state object, the institute undertake research, educational and training orient programs, including publication and information service in the field of labor, employment, and factory and boilers. It publishes bulletins, namely Sarmarapana, Prabhasika Samika, Shishu Sampada on quarterly and annual basis. At paragraph 7 of his evidence, MW1 deposed that the research work is done in the institute by eminent trade union leaders, professors of university, scholars and lawyers in resolving problem of labor related issues like migrant labor and child labor. It is also clear from the evidence that the organization of the first party management is not directly or indirectly carrying on any trade or business. It is very vital point, my lord. Business and its activities does not result into production and distribution of goods and service calculated to satisfy human wants and wishes. It is further clear from the evidence that organization of the first party management is giving training to the officer of the labor department, trade union leaders, and other participants free of cost. And that free of cost I will satisfy later on, my lord, because it is nowhere mentioned that they are free of cost submitting, but rather they are taking the fees, my lord. Cost by utilizing the funds released by the government, and it has no independent source of income. It transferred from the evidence that the management and the bulletins published by the first party management organization are distributed freely for awareness generation of public and the knowledge acquired by the result of research carried on by the institute is not sold by utilization of the government. MW1 also provided the exhibit D and E. Exhibit
Yes, you go on. Continue.
Exhibit D I will submit, my lord. From the evidence of MW1, the documents relied upon by and proved by him, it is clear from that the organization of the first party management is not an industry, even though it carries on research systematically with the help of employer. So,
yes, continue in your
my lord. So, physical research laboratory,
Mr. Nayak.
My lord.
Mr. Nayak, this is Physics Institute. This is an institute.
My lord.
Imparting training.
My lord.
Have you read section 2J?
My lord.
Read section 2J. For our view, you are unnecessarily wasting your time. You have a remedy elsewhere.
No, my lord. I will satisfy the furtherance. I will go, my lord, by 10 minutes, my lord. I will go that day. I will, my lord, satisfy
that this is an industry.
Yes, my lord. I will satisfy, my lord.
Okay, we'll hear. There is no issue.
No, my lord.
But first come to definition 2J.
My lord. Industry means any business, trade, undertaking, manufacturing.
1 minute. Let us get that. Yes.
Industry means any business, trade, undertaking, manufacturing, calling of an employer, and includes any calling, services, employment, handicraft, or industrial occupation, or the avocation of the workmen. Then, my lord, that it has come. Then, my lord, that
Go slow.
my lord.
Industry means any business, trade, undertaking, manufacturer or calling of employers.
My lord.
Okay, therefore,
There is a employer and employee relationship.
therefore, this is an industry, must be having some business,
My lord.
must be having some trade.
State, my lord. Profession also.
Profession code put
I guess it asila West Bengal.
Sorry,
My lord, seta.
definition doesn't say so. We are on the definition.
My lord, yes, my lord.
Definition just
Yes, yes.
include
Yes, my
profession.
lord. Yes, my lord.
Definition only say it must include business,
My lord.
trade, undertaking, manufacturer or calling of the employer.
Employer. Yeah.
And includes
Any
calling,
calling,
service,
any kind of services.
employment, handicraft or industrial occupation or avocation of the workman.
My lord.
Now straightway come to the judgment supporting you.
My lord.
Because backgrounds are taken, well
Well.
taken note. The labor court has also discussed what is the activities of this establishment.
My lord.
Now show us judgment that
My
yes,
lord.
somebody is giving training.
But
That's
my-
our Odisha Judicial Academy industry is.
Again, it
So I don't decision they can. Decision they
my
can straightway go to decision.
lord, my lord.
The sole question is whether this comes under 2J or
My lord, what happened that what I am submitting the judgment, that judgment is held in the West Bangalore water supply case, my lord.
दियंतु judgment.
My lord.
Bangalore water supply टा जाइची full bench larger bench को जानचन ना नहीं.
Again,
So
7
larger bench रे any outcome हेलानी.
ना है नहीं तापर
ହେଇନି ଯଦି ତାହେଲେ judgment implementation ହବନି.
again a judgment and that judgment what I am relied the it is also relied in the labor court, the physical labor research, my lord, that was held elaborately, that was held, my lord, and your lordship kindly come to the judgment. I have already given 140 industry means what he has
That's
defined.
fine. Which is that judgment?
The judgment is physical research laboratory versus respondent KG Sharma. I have already given on last occasion. Physical research laboratory versus respondent.
और citation दौनांती.
But again, AIR 1997 Supreme Court 1855, my lord.
Yeah, 1997 that has been referred there.
But that is referred there, my lord.
Okay, 97 Supreme Court page
Page 1855,
1855.
my lord.
Yes, you have filed the copy.
Yeah, I have already filed, my lord.
Okay.
Last occasion, I have already given 2 copies. And before that, your lordship, what I am submitting.
No, not before that. We will go straightway to the law.
My lord, no, for your kind indulgence, your lordship kindly counter the memorandum articles,
No necessity, no necessity.
and that has not held by the court below, my lord.
So you satisfy through law that yes, you have a case.
And it is satisfied.
No, not necessary.
Funds of the institute.
Come to decision.
Funds of the institute, my
You
lord.
are not understanding the intricacy involved there. You are,
Yes, my lord.
you are
Yes, my lord.
troubling your client. That is our impression.
I am suffering, my lord.
Yes.
I am suffering last 2007, my lord.
Yes, yes.
Because again,
You make the
My lord,
client
my lord.
further suffering for your conduct. Yes, come to the decision.
My lord, my lord.
You come to the decision. Yes, we have got the decision.
My lord, 143, your lordship kindly comes. The
Yes.
dominant nature to test, my lord.
Page 143.
143. IV 143.
Just 1 minute. Yeah, 143. I mean 143.
I am
para.
again, paragraph 143.
Seটা পারাটা 1.
Para নাই সেটাকে রেফার করা হয়েছে
So para 7.
para 7 4, my lord.
para 7 রে সে বাঙ্গালোর ওয়াটার সপ্লাই রে কোট କରିଛନ୍ତି.
Again.
ବାଙ୍ଗାଲୋର ୱାଟର ସପ୍ଲାଇ ବର୍ତ୍ତମାନ ଆଉ ଇଏ ହେଇଗଲାଣି, ବର୍ତ୍ତମାନ ଲାର୍ଜର ବେଞ୍ଚ କୁ ଯାଇଛି।
এইটা আগে 5 judges benches, সেটা 7 জনের benches.
কোর্ট
এই judgment টা আগে চলে দিয়েছি that they rely.
Now it is referred to larger bench or not?
That one.
Yes.
Yes, that was larger bench.
So larger bench যদি ଯାଇଛି তাহলে ইফেক্ট কোন সে জজমেন্ট র?
Again.
Unless the larger bench judgment comes.
My lord. না খালি আগে এই পোরশনটা খালি পড়ুছে আগে আমি। The dominant nature test টা কোন কোয়া হইছে? Where a complex of activities.
Mr. Naik, why you are reading the quoted person? My lord asked you to read the Bangalore water supply itself.
Again. Again, nature টা
You are going to a judgment where it has been quoted and you have filed you refer to the original judgment itself.
Again.
143
ମୁଁ ଆଜ୍ଞା
ପଢୁନାହାନ୍ତି
why-
judgment ରୁ
ଆଜ୍ଞା ମୁଁ ଆଜ୍ଞା କାଇଁ ଇଣ୍ଟରପ୍ରିଟ କରୁଛି କି that properly
Sir,
the-
ଆପଣ
So Bangalore
interpret
water work
କରୁଛୁ।
judgment ଆପଣ ଫାଇଲ କରିଛନ୍ତି ସେଇଥିରେ ଆସୁନାହାନ୍ତି
ଆଜ୍ଞା ମୁଁ ଏଟା ପଢୁଛି ଆଜ୍ଞା
Bangalore water work judgment କୁ ଆସନ୍ତୁ
ଆପଣ ପାରା 7 ପରେ 143 ପଢୁଛନ୍ତି ପାରା
Some
7 is a
judgment,
quotation
somebody quoted
ଆଜ୍ଞା the question what is the industry under the
କୋଉଟା
industry
ପଢୁଛନ୍ତି ଆପଣ
ଆଜ୍ଞା ମୁଁ ଏଟା ପାରା 7 ପଢୁଛି
ଆଁ?
ପାରା 7 ଟା
No, don't read there. Come to the judgment. There the Bangalore water work judgment has been taken support.
ଆଜ୍ଞା ଗୋଟେ
So why are you not coming to Bangalore
ଆଜ୍ଞା,
water judgment?
12 paragraph କୁ ଆସନ୍ତୁ ଆଜ୍ଞା my lord 12 paragraph 12
ଆପଣ କୋଉଟା ପଢୁଛନ୍ତି sir you are getting confused
judgment sir
which judgment you are reading sir
I am
Physical
reading
Research Institute or Bangalore Water Supply
ନାଇଁ Bangalore water ନାହିଁ
you are not
ନାଇଁ
referring
ମୁଁ ଆଜ୍ଞା
to-
institute
we will record that you are not referring to Bangalore Water Supply
physical research laboratory versus KC ଶର୍ମା AI 1997 ଯୋଉଟା ମୁଁ କହିଲି ଆପଣଙ୍କୁ
ହଁ ଠିକ ଅଛି
ସେଇଟା ପଢୁଛି ଆଜ୍ଞା
ଆପଣ କମ୍ପ୍ଲିଟ କରନ୍ତୁ ଆପଣଙ୍କ ସବମିଶନ you
ଆଜ୍ଞା।
don't understand yes all right you go on in your way
my lord 12 ନମ୍ବର ଟା ଆଜ୍ଞା କହିଛି କଣ
yes para number
before 12 my lord your lordship kindly page 11 my lord clause 11 my lord what respect to research institute by this court in Bangalore water supply has observed that does research involve collaboration between employer and employee it does the employer is the institution the employee are the scientist para scientist and other personnel is scientist research services undoubtedly it is its discoveries are valuable contribution to the wealth of the nation such discoveries may be sold for a heavy price in the industrial or other market technology has to be paid for any technological invention and innovation may be patent and sold in our scientific and technological age nothing has more cash value as intangible goods and inavailable services the discoveries more cash value and intangible goods and invaluable services than discoveries for instance the discoveries of Thomas Alva Edison made him fabulous rich it has been said that his brain had the highest cash value in history for he made the world vibrant with the microwave discovery of the record sound unlike most inventors he did not have a way to get his rewards in heaven he received it manifestly on this gratified and grateful earth thanks to conveyance of its invention into many aliens research benefit industry even though research institute may be separate entity disconnected from the many industries which funded that industries may be separate entity disconnected from the many industries which funded that institute itself it can be regarded as organization propelled by systematic activities modeled on cooperation between employer and employee and calculated to throw up discoveries and invention and useful solution with benefit individual industries and the nation in terms of goods and services and wealth it follows the reasons research institute always runs without profit motive our industry that describe that is the industry even the research institute that who fulfill this conduct my lord then 12 PRL is an institute under command of
Mr. Naik in PRL Physical Research Laboratory
yes
what is the ultimate conclusion of the Honorable Supreme Court
conclusion my lord the matter
which paragraph can you please find
my lord again
Agya paragraph
discouraging
sir which paragraph is
13 my lord
kindly read that
sorry I am more the institution discharging government functions
para
and
13
my lord last paragraph
it is not matching
yes
it
my
is
lord
nobody's case
it is
para
nobody's
13
case yes my lord nobody's case no
kindly read that
my lord
kindly
is
read
nobody's
the beginning
case.
slowly
pura padata padha
it is nobody's case that PRL is engaged in activities which can be called business trade or manufactures neither from the nature of its organization nor from the nature of its character of the activities carried on by it can it be said to be an undertaking analogous to business or trade it is not engaged in commercial industrial activities and it cannot be described as a economic venture or commercial enterprises of it is in its object of product and distribute service which would satisfy wants and need of the consumer community. It
Word would change. Don't change the words.
My lord, my lord.
So upon
It
produce ku kailani product. So don't change the words.
It
That
is
would have-
more an institution
Yes,
discharging a government.
Slowly.
Yes,
Slow padile, I think you will not miss.
My lord, my lord.
So, and stop
It
where
is-
there is a full stop and where is a
It is,
comma.
it is more an institution discharging governmental functions and a domestic enterprise than a commercial enterprise. We are therefore of the opinion that PL is an industry, even though
Sir, not chat dele, sir.
it is not an industry, even though it is carries on business activities of research in a systematic manner with the help of an employee, or it lacks of the elements which would make it.
As it lacks that element. Kindly reads. Don't change the words of the Supreme Court. We can't change. We may change, but we have a difficulty in changing those words. Kindly read that. Yes.
Well.
As it lacks the element.
Just a minute. Well. Carrying on,
As
it lacks
that element.
that element
should
which
make
would,
it an
which would make it an organization carrying on an activity which can be said to be analogous to the carrying on the
carrying
on trade
of a trade.
or business, because it is not producing any distributing
And
my lord, and
kindly
distributing,
just concentrate.
In proper say.
producing and distributing services which are intended or meant for satisfying human wants and needs as ordinarily understood.
Then kindly plead further.
My lord.
That is also important. We therefore
Allow the appeal and set aside the award of passed by the labor court in Ahmedabad in the reference number CL.
so kindly then turn to paragraph 4 of that judgment, which you are relying. What? Para 4, first line. Just read 2 lines, you will get it.
My lord. The labor court rejected the contention of the appellant that it was not an industry within the meaning of section 2J of the ID Act, though it recorded as finding that PRL is purely a research institute and the research work carried on by it is not connected.
It is not.
Not connected with the production, supply or distribution of goods or services yet. It took the aforesaid views following the decision of this court in Bangalore Water Supply and Storage Board versus A. Rajappa, so and so.
Stop there.
Again.
So now you get it. So that contention
My
was
lord.
rejected by the tribunal
My lord.
or the labor court.
My lord.
So that has been set aside by the Supreme Court. Following paragraphs 142, paragraph 143 of Bangalore Water Supply.
No, my lord, paragraph 12 is very essential.
It helps you.
My lord, paragraph 12 is very essential, my lord. Paragraph 12 PRL is an institute under the government of India's Department of Space. It is engaged in pure research in space and science. Research service training.
So that is in English, not in Odia. The judgment is in Odia.
No, I am.
So kindly continue. You don't
yes, sir.
add your Odia interpretations or interjections.
It is engaged in pure research in space of science. What is nature of its research work is already stated earlier. The purpose of the research is to acquire knowledge about the formation of and evolution of inverse, but the knowledge thus acquired is not intended for sale. The labor code has recorded a categorical finding that the research work carried on by PRL is not connected with the production, supply or distribution of material, goods or service. The material on records further discloses that PRL is conducting research not for a benefit or use of others, though the result of research work done by it are occasionally published, they have never been sold. There is no material to show that the knowledge so acquired PRL is marketable or has any commercial value. It has not been pointed out how the knowledge acquired by PRL or the result of the research occasionally published by it will be useful to persons other than those engaged in the such type of study, my lord. The material disclosure that the object with which the research activity is undertaken by PRL is to obtain knowledge for the benefit of the department of a space. Its object is not to render service to others, nor the fact it does not accept is an indirect manner. So, my lord, this is only this is space of research is only for the space of, but it is not it's a training.
Can this court distinguish PRL sitting here in a division bench?
My lord.
Can a Supreme Court judgment be distinguished?
No, my lord. What
So it has to be followed. No,
Yes,
let
yes,
us have a very fundamental.
Yes, my lord.
So
It
we
has to
have
be-
to follow. We have
My
to
lord.
follow Bangalore water supply and as interpreted, Bangalore
lord.
water supply interpreted by PRL.
PRL.
We can't distinguish it.
No, my
You
lord.
agree there?
No.
Fine.
So my submission, my lord. Hello, for a moment, my lord, they have relied that memorandum article, the rule is very clear, my lord. That my humble submission, your lordship, kindly glance that rule, my lord. For a moment.
Rule
But-
is very clear on what?
Rule very clear, my lord. There, the function
On
and
what? On what? That it is the industry.
the rule is there is commercial nature, my lord.
Huh?
That rule is very commercial nature. Because your lordship kindly page 69, your lordship kindly, for a moment, my lord.
Yes.
Funds of the institute, my lord.
Hmm.
The funds of the institute consist of following, my lord. Number one, grants made by state government, central government. Number two, donation and contribution from the other sources. Number three, fees and charges collected by the institute for service rendered by it.
Mr. Counsel,
My
Mr.
lord.
Naik, na, Mr.
lord.
Naik, you are failing in distinguishing between an industry and a service establishment. You may bring it within the fold of 226. That doesn't mean that an institution come within the definition of 2J. You are failing in understanding. We have been hinting something to you from the beginning.
No, my
Other
lord.
day also, you are not picking up that.
No, my lord. That
You
triple
are only
test.
troubling your client. You may argue for hours. There is no issue.
No, my lord. That's
There is no issue.
that two judgments,
Mr. Naik,
my lord.
how many industrial cases you have done? How
Almost
many industrial cases you have done?
in lower court, no, my lord. It is here, my lord.
Oh, it is here. You are expert in High Court in dealing with industrial cases. How many cases you have done in High Court industrial cases?
Almost 50, my lord.
Almost 50.
Yes, my lord.
Oh, this is your standard after conducting even 50 cases.
No, my lord.
Taking them as a state.
No, my lord. That followed the triple
So
test.
therefore,
That qualifies the
there is
triple test,
no
my lord.
help. There is no help to do
No,
this.
my lord. That qualifies the institute qualifies the triple test. What the two judgments of Supreme Court has held, my lord.
Okay, all right. That's your understanding who can help you, right?
And in your lordship, kindly have a glance to that page 68. What is the function of the executive council?
Just read Article 12. Article 12 of the Constitution. Then realize what fell from my lord. Because
Failing in
I think
understanding.
you,
My lord, your object.
apart from your,
We have given sufficient indication. You are not following that. That's why we clearly said you are troubling your client only, wasting your client's time. It may be luxury to you arguing these subjects.
My lord, the function and the course content by the institute, my lord, you kindly have a glance, my lord. The training, labor research and publications. So training is there on payment they're giving. That's why they're receiving the
Training is
charges.
the industrial activity. Right.
Yes, my lord.
All right. That's your submission. Okay.
Not industrial institutes, my lord, the training, what is that they are giving the training. The institute shall take up the three types of training for the benefit of rural and unorganized laborers, factory managers. Again, they are giving the training to factory managers, and out of that, they are taking the my lord, fees, my lord.
All right. You
And
complete.
trade union leaders, office of the director of labor, that part director manus but the managers and trade union leaders, factory boilers and officer and staff of other department of government relating to management of labor, employment of factories, the training for the unorganized and rural labor shall almost consist concentrated to the right and prospectus of rural labor and envisaged under the different labor law, including vocational training of the children of workmen and workmen labor, training for the factory managers, etc. And the activities of the Page 68, functions and power of the executive council, my lord, for a moment, my lord, and to the clause 2, my lord.
Yes.
To receive and to have custody of the fund of the institute and to mortgage the property of the institute. The my lord, deed hela to enter for and on behalf of the institute into agreements, including those containing the arbitration clause. That means whereas the arbitration clause is there, it is a
that capacity. All right, yes, what are your other arguments?
and my lord, the to accept the management of any endowment, trust or fund, suspicion, donation, provided that it is not a that is also they will accept the funds and the systematic activities with the employer and employee and the organizing training what they are giving is the without the employer and employee that cannot be held.
Come to your evidence. This is a statutory proceeding, you know.
No, that
Come
evidence
to your evidence. Where have you submitted all these things?
that is not reflected, my
Come
lord.
to your evidence.
My lord.
What is your evidence here? What light you have thrown on the aspect of industrial activities of the industry, of the establishment involved? Evidence.
My lord, though exhibit EU was
Just 1 minute. Have you filed the copy of evidence?
yes, my lord. Only the
No. Yes, only
No, my lord,
that page where have you filed that evidence? Copy here.
that evidence they have relied, my lord. Exhibit E.
Oh, we are asking a question to you. Answer on that.
My lord.
Where is your evidence available on record? Who is there? Who is there intervening? Yes, where have you filed copy of evidence?
My lord, my counter 54, it has been given, my lord.
Page.
Page 54, my lord. Annex C.
Page 54.
My lord.
Of the brief.
Of the counter, my lord. Counter file.
Evidence, affidavit evidence. Oh, block. Who is intervening? Live he gala ta ji duty khol de kiri copy le seti basikibe. If necessary, live ko block karibo la. Jodi bahar ki intervene korchante, live ko block karibo. Yes, come to.
Okay. 55 page 7, paragraph 7, my lord. The second party workman is
the brief. What have you stated in your evidence on the industrial aspect of the?
My lord. That the second party workman is a workman within the meaning of
Just 1 minute. Let us get. Let's come to page 54. Page 54.
And the first party management is an industry within the meaning of 2J of the Industrial Dispute Act.
Just 1 minute. WW1 ro page 54 unnecessary setup. Yes, come to para 7.
My lord. That the second party workman is a workman within the meaning of under section 2S of the Industrial Dispute Act, and the first party management is an industry within the meaning of under section 2 day of
So
J of,
this is all you have submitted.
my lord.
For last 20 minutes, you are arguing something out of record.
No, my lord. That,
You,
my,
is your evidence disclosing all these arguments you have built?
yes, my,
up?
I have all, my lord, what I am submitting is that we have already given the note of argument that is not reflected in
Note
the
of
order.
argument cannot form
Yes,
written
yes,
statement.
that I have
It
already,
must be
I have
evidence.
already argued this before
No,
the
sorry,
law.
sorry,
And it was already,
sorry. It's a trial. It's a trial.
no, my lord. Trial.
It's not a trial.
Yes, my lord, trial.
No कौन कौन सब
No, no, no.
जिनिस रे.
Is a trial, my lord.
No कहीं कौन सब जिनिस रे.
No. It is a trial.
Commission.
Your Lordship, on the basis of the written statement filed by the management before the court below, the Labor Court has framed two issues, whether the organization of the first party
Come
management
to your
is,
written statement where it is available.
I have filed in my counter at annexer.
Running page कहीं no नांती.
Annexer A, my lord, page 45 of my counter.
Page 45 of your counter.
Lordship.
Just 1 minute.
Paragraph
Yes. Please. What have you stated on the industrial activity?
Yes.
In your dispute there?
Kindly, paragraph 2, my lords. The
Yes.
present reference is not maintainable in the eyes of law.
That's a bold claim.
And in paragraph 3, my lords, the first party, that is the State Labour Institute, Bhubaneswar, is a state government sponsored autonomous body registered under the Society Registration Act. It is a premier institute not only in the Odisha but also in the country, which is created by Labour and Employment, presently ESI Department of Government of Odisha by resolution so and so, and comments its functioning from 1/5/1993. The General Council of the State Labour Institute Odisha, in its meeting held on 21st December 1994, under the chairmanship of Honorable Minister Labour and Employment Department, Government of Odisha, adopted the resolution accepting the rules and regulations of the State Labour Institute. The triple objectives of State Labour Institute are research, training, and publication on labor and HRD related issues. The objectives of the State Labour Institute are to initiate and promote the professional activities in the field of labor and related matter, and to undertake action-oriented research, educational and training programs in the field of labor and employment management. Your Lordship, on the basis of this material on record, the management has laid evidence before the Labour Court.
Where is that management evidence?
Paragraph annexer B, my lords. Page 50.
Annexer D.
Annexer B. B for Bombay. B. Page 50, my lords.
Page 50.
Yes, my lords.
50.
Yes, lords.
Yes, immediately after written statement. Yes.
And the same pleadings were also in paragraph 5, page 51. The objects of the State Labour Institute is stated in para 3 of the Memorandum of Association of Bylaw, which provides that the objects of the institute are to initiate and promote professional activities in the field of labor and related matters. In conformity to the said objectives, the institute undertakes research, educational and training programs, orientation programs, including publication and information services in the field of labor, employment, and factories and boilers. Stop. The institute is publishing 3 bulletins, namely Shrama Darpana, Prabasi Shramika, Sishu Sampada on quarterly and annually. Moreover, a labor law roundup was being published by the State Labour Institute for creating awareness. So these evidence of the
para 4, 5, 6, 7, all these.
Yes, Lordships.
You have stated with regard to
the activities of the State Labour Institute. And that does not come within the purview of the trade or manufacture or business or undertaking.
What decision you take support?
Lordship, the Physical Research Laboratory versus KG Sharma, we have relied upon this decision before this.
Citation?
97.
That
Yes.
97 you bank.
Yes, Lordship.
तार 97 रो से पाराटा को से बैंक करूचंती आपण होल 97 जजमेंट टाको बैंक
Paragraph 12 and 13 of that judgment is very relevant. And the court also distinguished.
help of some discussion there you say this substance but the ultimate judgment but ultimate judgment board is so this is argument
Paragraph 12 and 13 are, they have distinguished how it is not coming within the purview of industry.
para 12 and
12
13
and 13. Yes, sir. And that is, there is a categorical finding recorded by the labor court that the organization is not the activities of the organization comes within the purview of industry or professional undertaking in the activity. Rather,
all right we close the yes it's set at the yes had the submission of the respective councils hearing concluded judgment reserved LCR Sanger Royal. Eta भी रही
I have already relied another judgment, my lord. I have already given. Another judgment I have given, my lord.
What is that judgment?
My lord.
Citation कौन
2012 Supreme Court 1 OLR 955.
2012
Supreme Court 1 OLR.
Supreme Court.
Supplementary, sorry. 2012 Supplementary 1 OLR.
Supplementary 1 OLR.
My lord. 955, my lord.
Supreme Court judgment?
No, I'm Odisha High Court judge.
Odisha High Court judgment.
I've already given, my lord.
Right, all right. Yes.
Item 12.
Eta rahibo ta power ta ta bhitar. Yes, item 12. Yes, sir. This is a matter pending since 2017. Nobody is showing interest. Stand dismissed for non-prosecution. Counsel for OP1. Sanjeev Swami, Sri Sanjeev Swami, counsel for OP1 present in court. Dismissed for non-prosecution. Any interim order?
No. This prayer was only for consideration of the representation by Paradip Port Trust.
Okay.
That was the prayer.
Yes, next.
Item 13.
This is a matter pending since 2017.
13, my lord, I am for the OP number 8.
Pardon?
I am for the OP number 8.
Okay, let us. Yes, there is no appearance on behalf of the petitioner. However, there is appearance on behalf of the OP number
8.
8, state as well as OP number 8. Voilà. Dismiss for non-prosecution.
Item 14.
May I please Lordship, I'm submitting a
Yes,
written.
14. Just submit in the previous case, I will put it. नहीं तो इतने संदेह नहीं Sargu,
Yes, sir.
what is this? What is the?
I have come up. I'm
What is
submitting.
the order of challenge?
May I use the written notes?
Written note. आगे टे कौन तो कौन
Court.
challenge करछन दिदियों तो.
Lordship, you have challenged the ex parte order passed against it.
Yes, what happened to your attempt for settlement?
It failed, your lordship. It failed.
No proposal has been made.
Settlement failed.
Yes.
No
Your Lordship.
proposal has been given. Your lordship has a glance
No
to.
proposal
Lordship.
has been made.
No,
even.
madam.
May I pray?
But
Lordship has a
she,
glance to
she
order
says fails, so therefore let us enter into merit. We record that only.
May I pray, Your Lordship?
Yes, like a counsel for petitioner, even though submits there is a failure of the settlement. This court, however, counsel appearing for opposite party, contesting opposite party submits, there is no proposal even. Okay, be that as it may, this court is not inclined to adjourn the matter any further and enters into final hearing.
No, Your Lordship. I don't pray for an adjournment. I don't pray for an adjournment, Your Lordship.
Huh?
I don't pray for an adjournment.
No, we don't record adjournment.
Yes.
We say we will enter into the hearing.
Yes, Your Lordship.
Yes. Okay, counsel, okay, see the rejection. We don't, we are not inclined, counsel for the petitioner seeks hearing disposal of the matter. So matter is taken up for hearing. Now argue. What is the challenge?
You have come up against the ex parte order passed against me, Your Lordship.
Ex parte order passed by
Passed by the learned labor court, Your Lordship.
labor court.
Yes, Your Lordship.
Kindly refer to that number of that proceeding.
It's under
That ex parte order was passed in which ID case or ID miss case or whatever
Yes, Your
nomenclature.
Lordship. That's under annexure 10 of
ID
my-
case 4 of 93.
No, Your Lordship. It's ID case 9 of 2016.
Miss case. 33 C2 proceeding.
33.
33 C2 is
That is a computation under section 33
That's a
C2.
computation aspect.
Computation.
One
So
page.
annexure 10.
Yes, Your Lordship.
Annexure 10, you say it's a ex parte order.
It's an ex parte order. Yes.
You are workman.
I'm for the management, Your Lordship.
You are for management. You are for management. So what do you find that this is ex parte? There must be order ex parte making you ex parte.
No, Your Lordship, no notice was ever served on me.
No notice was ever served.
No, Your Lordship. I didn't receive any notice, Your Lordship.
LCR will.
Okay.
If Your Lordship
Page LCR is not yet there. Page 176, Your Lordship may see running page 176, paragraph 2.
176
My Lords,
is para 2.
para 2, Your Lordship.
Notice was issued to the OP through registered post where so and so. More than 1 month has elapsed. So therefore he has taken the period into account and held that there is no
Yes, Your
appearance
Lordship.
therefore.
My Lords.
So be that as it may, be that as it may. Now it has been allowed.
It has been allowed again.
Allowed.
Yes, Your Lordship.
Then you do one thing. If you have
Lordship.
specific allegation, which para that you have been not noticed, which para you have made the allegation? Because once that is
In my
extra-
repetition, Your Lordship.
Your specific allegation in the, by way of pleading in the writ application that you were never served with notice.
Yes, Your Lordship, I have,
Please be
Pleading.
on mic. Mic टाको आपनकर set करंतु.
am I audible?
Yes, which para?
Still you can bend it a little below so that while reading.
आउटे तळु कर दियंतु. आपण पढिला बेले तळको मुह कर दोछन ना से difficult होची सोडा. Yes, which para you have pleaded that yes, even though there is recording of service of notice, but you were never noticed.
Yes, Your Lordship. Para 16, I suppose.
Which
Para
para?
15, Your Lordship.
Para
15, 1-5.
1-5.
That the aforesaid order passed under annexure 10
Just
has
1
been.
minute, 1 minute. 1-5 कला बेले page type.
Page 20, Your Lordship. I'm sorry.
Page
Page 20 of my writ petition.
20. Yes, read para 15.
that the aforesaid order passed under Annexure 10 has been passed behind the back of the petitioner is liable to be set aside on the account of violation of principle of natural justice, inasmuch as, though the notice stated to have been sent by registered post, in fact, was never served on the chairman of the petitioner trust. Had it been known to the
But you
petitioner,
never say, okay, registered post, in fact, which was never served.
it was never served.
Hmm.
Had it been known to the petitioner, there would not have been any reason at all
And
for not
the,
bringing
and
the
the, what the tribunal observed here or labor court observed here, that 1 month has lapsed.
1 month has
1
lapsed.
month have, then it could have collected the service report. Has he recorded? Neither the brief nor the AD has come back.
Nothing has.
Para
such-
3,
Nothing
para
as
2,
such has
Mr.
come.
Mishra, read again. Has he
Lordship,
recorded? Neither AD nor the brief has come back.
No.
that part he has not.
He only
Your
says
Lordship.
more than 1 month has elapsed. In the meantime, after dispatch of the notice, service notice were deemed to be sufficient.
Deemed to be sufficient.
That
Lordship,
should have been recorded by him.
that should have been recorded.
Or else, it's a serious issue. It's a calculation aspect, execution.
Lordship,
It is execution.
my lords, my lords.
So therefore, the appearance of the party with utmost care should have been ensured.
Lordship,
Now, yes, we propose.
Lordship,
We propose. You are for management.
I'm for the poor workman, your
Okay,
lordship.
ठीक है. Poor, sunandu. You are the poor workman. Workman is always poor. Management is poorer for the conduct of the workmen always. कौन होती सब industry देखो ना go काली कौन हल्ला? Management is becoming poorer. Adani कौन हल्ला? Management is becoming poorer. आउट उड़ा जो किंगफिशर थिला से बाबू विदेश रे घोड़ा खेल खेलुचंती से भी poorer. So then country becomes poorest. Poorer, poorest is out country. Some industry fail କରୁଛି. Therefore, best way is your amount will be insured. Your amount will be insured by deposit. You will be paid also cost for there is unnecessary suffering to you. Okay, some cost will be paid. You go there, we are remanding the matter. You go there and we'll target the matter. Both of you will appear.
Yes, your Lordship.
And will target. And the background, but with the madam, you are to reconcile with the background. There is already an industrial adjudication
May I submit, your
being
Lordship?
confirmed by Supreme Court.
Yes, your Lordship.
High Court and Supreme Court.
That was for
Therefore,
regularization.
it's only calculation aspect because the merit cannot be gone into.
No, your Lordship.
Outcome in the award has to be adjudicated. Therefore, 2 dates sufficient. आपंकर calculation टा produce करिवे, से calculation देइथिबे जे as an outcome of the award, this will be our due. आपण calculation देबे, they are in entitlement of so much, से दीटा के से धर की calculation रे arrive करिवे.
And Lordship, good submission.
By chance, in your pleading, have you stated anywhere that this cannot be the calculation?
Lordship, absolutely. In the award, in the previous award.
What was the
That
award?
was,
Let us see.
Annexure 1 of my writ petition, your Lordship.
Page.
That is at page 23.
Page 23, award ends at where?
41.
41, your Lordship.
41.
Yes, your Lordship. That was the award part.
Oh, let us see what was the award. Yes, 41.
That was
In the result, I am of the 10 report.
In the result, I am of the view that the action of the management in not regularizing the service of Jugal Kishore Baral and others as permanent workmen is not legal and justified. In view of my finding in the foregoing issues, I am of the view that the member of the second party are entitled to be regularized with immediate effect.
So regularization is a consequential benefit.
That was for
And
regularization.
this was finalized when we were in High Court judgment.
I am filed along with my death cert, your lordship.
Along with date chart.
Your lordship.
Background Along with date set you have filed.
My lord,
There is a date set here. Ah,
My-
yes, date set,
below to the, just below to the date set. Your
just below the date set.
My lord, OJS
Yes.
number 13426 of
Just
1999.
1 minute, 1 minute.
My lord.
Go slow.
Sir.
Go slow. Yes, this is WPC OJC rather.
OJC number,
Oh, it is a very old matter.
my lord,
Yes, your lordship.
Now the 99 decided on 27/4/12.
2012. Your lordship.
It's decided in two thousand
Okay,
twelve, your
then it
lordship.
was being heard in single bench.
My lord. Then they have moved to the
So ultimate conclusion page,
lordship,
For the
order of
Supreme-
the SLP, so also the review petition. They have moved before the Honorable Appeals Court.
just 1 minute, page कोटी conclude है judgment टा.
ता तौले sir. The High Court order below to
Yes,
the
page, last page.
My lord.
Keeping in with the aforesaid discussion, this court comes to conclusion, there is no merit in the writ petition, same is dismissed. Hmm. Okay, now Supreme Court order please, last one. In the written note,
My lord, last 4 pages, your lordship.
okay, can you tell the date of order?
Lordship, SLP was dismissed on 27
Thereafter, there is also a
review, lordship.
review.
My lord.
So SLP dismissed by, okay. SLP ହେଲା
21/1/2013. 21st.
SLP এটা কেবଳ ଇଏ CC registration.
My lord.
1903 of 13 କେବେ dismiss ହେଲା? Special petition dismiss.
21st of January 2013.
21st of January.
Sir.
Then a review.
My lord.
Review re delay condone but review dismissed.
My lord.
Yes. All right, we are proceeding for the order.
One, I want
But
to,
there is long suffering, madam. Of course, you may, if you say there is no service of notice, you may not have a responsibility, had the submissions of the respective councils.
Lordship, we had also previously noticed them. to-
Pardon?
We had also, after the order of the Supreme Court, after dismissal from all the forums, we had issued notice to them to regularize them in service.
Huh?
We had issued notice to the workmen to regularize them back in service, your lordship.
You have issued notice.
Yes, your lordship. We had.
Then
issued-
what happened?
What happens, your lordship, is that they were working as manual compositors. And in the meanwhile, the process has become digital. And they say they have no technical knowledge. Some-
Not?
They have no technical knowledge, your lordship,
Hmm.
or technical qualification rather. So, your lordship, what happens is that some manual works were assigned to them, but they remain absent.
That's a further cause of action.
Yes, your
We
lordship.
don't know if you have taken up in the way to work out the award. And in the process, if you find, but that was never your case in the writ application.
Yes, your lordship, I've mentioned everything in my.
No, in the earlier writ.
No, in the earlier it was only for regularization.
So you could have taken that stand, even though a regularization direction is given, they can't be regularized in such
We
post
have mentioned that, your
because they
lordship.
lack, if that is not considered or considered failed and again approved by Supreme Court, then that issue is gone.
And
So we are not there.
We are not
there
I
here.
want to, pardon your
You can't
lordship.
you can't also take up such issue even a 33.2. 33.2 is only computation as an outcome of a result in a
In the
award.
award, your lordship.
Award is culminated, award is finally approved by the apex court even in the dismissal.
I bow down to the award, your lordship.
So
I mean,
therefore,
I want to-
therefore,
one document, lordship, only one document.
on what?
After passing the order, we have immediately communicated them the order and they implemented it. After 3 and 4 months, they have referred the writ application.
That's right. That's right. They have a right to prefer. They have a right to prefer and we find a ground. It's ex parte order. There is no reasonable explanation recorded by the labor court even.
The order said it
He should have been careful when he's in a 33.2. Ultimately, what happened in 33.2? It is execution.
Yes, your lordship.
Then 33.2 ପରେ ଅଛି penal provisions ଅଛି. Attachment is your account.
after the
So
notice
it's
has
a
been-
very drastic situation. So utmost care should have been taken. How mase apekha kar jaytile kon suvidha hitanta?
as I remember, your lordship, in the original order sheet, that is the order sheet dated ethic, that has clearly reflected that 30 days has been passed, elapsed.
30 days passing merely doesn't give a go by. You must further record that neither AD nor the brief coming back. Even there can be obtaining of a report from the postal authority. Who issues notice ultimately?
Postal authority. Postal authority.
No. Who issues notice ultimately? Postal is serving.
Serving.
Who issues notice ultimately? You
Division-
file requisite.
My lord.
Labor court is
Labor court.
issuing. Its staff goes and files the requisites.
My lord.
So therefore, the labor court could have obtained, like we are obtaining here. Now tracking report is very much there. With the tracking notila, postal certificate would have that would have ended the matter. At the submission of respective councils, this revision involved the following relief. Background appearing. Okay, this court find the core dispute involving herein, involving an order at Annexure 10 in finalization of a 33C2 of ID Act proceeding by the Labor Court, Bhubaneswar, involving working out in terms of the award of the Labor Court. Award of the Labor Court or Industrial Tribunal?
Industrial Tribunal,
Industrial
your lordship. Page
Industrial
23,
Tribunal.
Annex 1.
Out of the Industrial Tribunal, Odisha, Bhubaneswar, in ID case number 4 of 93. Core challenge in the writ application appears to be there is disposal of the Basan, take your seat all judgment of appears to be there is disposal of the 33C2 of ID Act proceeding. Ex parte and behind back of the management involved there. Reading through the recording of the labor authority, labor court, by para 2, a claim is made. There is no denial. There is no possibility of denying the fact that there was issuing of notice to the management in the 33C2 proceeding. However, the management has been set ex parte merely on the ground that there is expiry of the 1 month period from the time of dispatch of notice, and the provision at section 27 of the General Clauses Act applies to the case in declaring the management as expired. Taking this court to the reading in paragraph 15, herein, counsel appearing for the petitioner submits, there is clear pleading of no service of notice on the management. Notice being issued by the labor court in the 33C2 proceeding on the management at all. Okay, this court here find the case has a checkered background. In the first instance, an industrial adjudication was made based on a reference of the competent authority as to whether the action of the page 23 reference ta quote kariba page 23 of the brief, internal page 14 and so on. This matter admittedly got disposed of on the contest of the parties with the following award. It page 10 and 11 quote karibo, page 41. The matter did not end here, as the management went in writ application in the challenge of such award in WPC number, in OGC number. OGC 13426 of 99. This writ petition again appears to have been decided on contest of the parties on 27/4/2012 with the following direction. Inverted comma, keeping in view the aforesaid discussion, comma, this court comes to the conclusion that there is no merit in the writ petition and the same is dismissed. There was further carrying of this matter to Hon'Ble Appeals Court in by the management in special leave to appeal civil -2013 bracketed occur CC 1903 of 2013. This SLB was dismissed at the stage of admission as follows. Inverted comma, delay condone. The special leave petition is dismissed. Matter again engaged in a review application moved by the management itself. Review petition civil number 1502 of 2013. This matter got disposed of with a dismissal of the review application by order of the Hon'Ble Appeals Court dated 23rd July 2013. Okay, with observing as follows. Inverted comma with a rakha, delay condone. We have perused the review petition and the connected papers. Next para. We don't find any error in the order impugned, much less an apparent error on the face of record, so as to call for its review. Next para. The review petition is accordingly dismissed. It would add after the submission of the management council para 15 plead in his opposition, learned counsel appearing for the workmen submits. These are poor workmen. Industrial adjudication was raised. Industrial adjudication was raised by ID case 4 of 1993, disposed of in 99. Management went on engaging such award passed therein till disposal of the review petition civil 1502 of 2013 in July on 23rd July 2013. It is only after the dismissal of review application the poor workmen got occasion to even were made to wait for long 3 years in absence of working out of the award involved herein, thereby compelling the workmen to prefer the 33C2 proceeding by the ID Miss Case number 90 of 2016, ultimately got disposed of in favor of the workmen on 5th July 2017. For there is passage of long 99 I did 93, 7 and 17. 24 years, and in the meantime, at least till institution of 33C2 proceeding, and in the meantime, there is loss of again almost 6 years time in the meantime. 6 years time. The poor workman has been sufficiently suffering. Thus, a request is being made by the council for the workmen, keeping in view the long lapse of time, to dismiss the writ application, to find closer to the industrial adjudication involved herein. Ultimately, তারপরে সিরিয়াল পড়ে আসছে, সিরিয়ালটা কোঠি এন্ড করলো, that is Supreme Court order. It is also brought to the notice that some workmen have been died in the meantime.
Three people
have been died in
substitute.
seটা
Three people have died, two people have substituted.
And there is substitution taking place in the pendency of the writ petition.
Pendency of the writ petition, one citizen has died.
Okay, in the meantime, chhadi diyon, choda kichi immaterial bartan. Immaterial. Some people have died, that we take record. Okay. Considering the rival contentions of the parties and keeping in view the development, taken note here in above, right up to the dismissal of the rejection of the attempt of the petitioner, management petitioner, by the Hon'Ble Appeals Court in the dismissal of the review petition ultimately. This court find undisputedly there has been sufficient lapse of time. Coming back to the merit, keeping in view the allegation of the petitioner that there has been no service of notice at all in the 33C2 proceeding, requiring interference in the order and giving a direction to the authority undertaking 33C2 proceeding for fresh adjudication therein in the involvement of the management. This court, examining the notice aspect on the management in the 33C2 proceeding, finds the level of the report has the following observation, para 2, 176 page. Reading the aforesaid, this court find and keeping in view that the proceeding involved a calculation aspect, first of all, there should have been utmost care in ensuring the calculation, submission of calculation at the instance of management, as ultimately the burden was to be loaded against the manager. Burden of release was to be loaded on the management. And secondly, this court find, though there has been recording of lapse of 1 month time, but unfortunately, the labor court did not keep in view the position in the service, either ensuring obtaining of service report, or at least even deferring the matter to, or at least even asking the workmen for adopting substituted service. Considering the nature of dispute being an adjudication through the provision of section 33(2) of the ID Act, this court find there must be involvement of there should have been involvement of the management before arriving at the calculation aspect. It is for technical rejection and without adopting proper care, keeping in with the seriousness in the matter, this court inclined to interfere in the impugned order and ascertain. While inclining to interfere in the impugned order, this court is also to keep in mind the suffering of the workmen involved herein for nearly 3 decades, as they are unable to reap the benefit of the award involving an industrial adjudication ended in Supreme Court. Considering there is sufficient loss of time, this court in interfering in the impugned order observed, okay, and setting aside the same, observe the order of this court shall be subject to management depositing the entire amount involved in the ID miscase number 90 of 2016 with interest at least 7% from the date of such award being deposited before the labor court,
There may I pray your
at
lordship?
least within a period of 1 month. Further, for the suffering of the workmen for all these years, almost nearing 3 decades, this court also feels it appropriate to grant cost at least a sum of rupees 5,000 to each of the workmen involved herein. 5,000 to each of the workmen involved herein, which will also be paid within a period of remitted to the account of the surviving workmen and to the account of the head of the legal heir of the deceased workmen, on account being furnished by such workmen, on their account details being furnished by such workmen. Allow with this observation, the impugned order and ascertain is interfered. However, for there is fresh adjudication necessary involving the industrial adjudication under section 32C of the ID Act. The matter is remitted back to the Labour Court, Bhubaneswar, for fresh adjudication at least within a period of 4 months. The proceeding will be reopened, subject to again the management files. Management makes the deposit in terms of this direction and also files receipt in proof of payment of cost to each of the workmen.
May I pray your lordship?
Yes.
Here in the order,
Okay, voice low.
here in this order, under annexure 10, your lordship, the one under challenge, your lordship, the the learned labor court has gone beyond its jurisdiction.
Oh, we have set aside that. We have set aside that, you
Yes,
know,
sir.
you go, we are also giving you, filing your objection there. You raise your objection there. We
if
are not deciding anything.
The entire money that has been calculated, your lordship,
Huh?
the entire money that has been calculated.
This has gone. You don't understand that we are set asiding Annexure 10. Nothing remains. Proceeding resumes.
Yes, your lordship.
So therefore, go and file your objection.
What's the amount to be deposited?
So this will be calculated again. This goes, this calculation goes.
Thus, it is your own creation. You did not took
We-
up
we-
the hint from the court earlier. And
we keep something for you. Don't worry. We keep something
No,
for
your
you.
lordship, because
you could have used your good offices and settled the matter.
Like both parties, for the matter is remitted back to the Labour Court, Bhubaneswar. The parties are directed, management and workmen, both sides are directed to appear before the tribunal, at least along with a copy of this judgment on 21st of June. 21st, କାହିଁକି ସେ ତ ବନ୍ଦ ନାହିଁ ନା ତାଙ୍କର
ନାଇଁ sir,
summer vacation
21st of May, your
so
lordship.
ମାସେ expiry କଲା ପରେ କରିଦବା ଡେଟ୍ ଟା
ଆଜ୍ଞା sir.
ହେଲା so ମାସେ ଆଜି ହେଲା 5 ତାରିଖ so let it be 7th June 7th କଣ holiday ଅଛି କି?
No, lordship, it is functioning. Labour Court
No,
is
June 7th is no holiday. June 20th ବରଂ ରଥଯାତ୍ରା.
functioning. Yes.
7th of June. ହେଲା 7th of June ଟା ବାରି ହଉଛି yes, it's Wednesday. Working day ଅଛି. 7th of June. ହେଲା 2023. Okay, for the remission of the matter, this court for fresh adjudication of the calculation aspect in the involvement of both management and the workmen, this court further observe the further release of the entitlement of the respective workmen shall be dependent on the ultimate outcome in the 33 to C2 proceeding.
Yes, your lordship.
From the deposit made by the management, balance amount, if any, shall be along with interest, shall be refunded in favor of the management. If any, if any, shall be refunded in favor of the management. Tribunal is a Labour Court is also directed on deposit of the amount by the management. Same shall be kept in fixed deposit in any nationalized bank for at least 6 months. 4 months hame direction de delu, 1 month delu apanku liberty to deposit. So 6 months FD re rohibo. Tonka jaha hobo se sethuru seti se tribunal re se tonka nei jibe au se hoboni. Release may be made. Okay, this court further also observe none of the observation herein will be made for any observation on the merit involving the case, and the Labour Court shall have its own decision in the dispute involved. Yes, without being influenced by any of the observation herein. କାରଣ ଆମେ 2 ବର୍ଷର ଯଦି କହିଦବା ସେ ରିଫଣ୍ଡ ସେ ରିଟର୍ନ ବେଳକୁ 1% କାଟିଦେବେ ମିନିମମ୍ ପିରିୟଡ ନ ହେଇଥିଲେ therefore 6 months ରହୁ both parties are directed not to take adjournment in the on the date of appearance management if so advised may bring its objection to avoid any further delay in the matter ହେଲା ପୁରା ସବୁ ଜିନିଷ ରହିଗଲା ଆଉ କିଛି ତ ଆପଣଙ୍କ ଆଉ କିଛି today रेस्ट केस जा रहिला आ किछि आदर के विथड्रॉ करछन्ती किछि नाही तो ओके देखा जीव नेक्स्ट वीक हुने
that 15 millard that has become infructuous.
कोटा
15
infructuous हे गला
माने the demand involving the assessment under 126 has been paid.
We trust you.
So
I'm appearing for the opposite
No,
partner.
Counsel for prisoner says it has gone infructuous. I am
appearing for the opinion number 1, my lord, with the complaint in the court below, my lords. I have deposited the.
We are dismissing the amount.
Yes, ma'am.
As infructuous.
Only I pray, my lord, liberty to be granted to file.
No, your prayer cannot be exceeded here.
Because
prayer you advise your client.
ଆପଣ opposite party कोन ताको petition ने prayer करछन
नहीं मो खाली जेतु तो तांगर मते
ଆପଣ challenge करछन्ती कि आपण तो challenge करि
नहीं मो challenge.
So you can't be granted a relief here at the submission of Sri Das and Sri Nanda. You are
no my
Asit Jena. Asit Kumar Jena.
Asit Kumar Jena. For the respective counsel, a memo has been brought on record indicating for there is already deposit of the desired amount. The matter has gone infructuous. Okay, for the memo declaring the matter, claiming the matter has gone infructuous, this court dismisses the requisition as has gone infructuous. Memo filed herein be kept on record.
Memo filed by the petitioner.
How come matter achi infructuous? Nahi, all right.
Memo filed by the petitioner. Memo filed by the petitioner.
Definitely. Petitioner dismiss kurcho ka memo. Yes, this is CMAPL.
Yes, madam.
Defect can I remove for Nandi? Petition was dismissed on the admission date.
Yes, madam. Fresh admission date on 2/2/2023.
Not assigned to bench. All right. Considering the petition was dismissed at admission stage, but for the non-appearance of the petitioner, looking to the ground stated herein, this court find Petitioner has a genuine ground of non-appearance. This court feels it appropriate to allow the same appear, thereby restoring the writ application. Yes, what is the writ application?
My lord, verification of the employees of verification of the employees of the MCL, my lord, Union Association.
Mic tolu karo.
My lord, verification of the employees of the MCL Culture Union, my lord.
Verification of
Employees of the union of the MCL Culture.
that how that comes in a single bench? Is it under verification of membership rules?
Yes, my lord. But next year one.
It is verification of trade union membership.
Because we are not party.
State government is not party, MCL is party.
No, MCL is a party, no dispute, but you say it is verification of membership. It comes in division bench.
Yes, I have filed the division bench. I have filed the case for division bench. 2 copies I have already filed.
So why how it has come for single bench? Court dispute appears to be verification of membership under the provisions of the Trade Union Act. Registry to find out the assignment and place the matter accordingly. It repeats under our. It is not a single bench matter. Yes.
Item number 2.
Aguru bhi direction hitala to find out. Again they are placing it single bench.
I have already filed a second copy also. I have also filed a second copy. I have also filed a second copy.
Second copy consciously filed.
Yes. Registry problem.
Right, therefore, the registry is to understand.
Lordship, my lordship, the annexure 12 is the impugned order passed by the London collector and confirming the order passed by the London sub-collector and application under section 4 of the Senior Citizenship Act 2007, your lordship. Here the present petition is the
You are the senior citizen or you are affected by the.
Yes, lordship, kindly clarify. I am the daughter-in-law of the present respondent, present opposite part number 3, your lordship.
The senior citizen.
Yes, your lordship. I am the daughter-in-law. My husband, the son of the opposite part number 3, already passed away since 2014. I have a minor son. I have staying in a house which that property was gifted the grandmother of the present husband of the present petitioner lordship. Now, what happened? My respected submission of the application under section 5 is not maintainable in the instance of the present opposite part number 3 against her daughter-in-law lordship.
Why?
Lordship, kindly glance
the act is to protect the senior citizen.
Yes, sir, that's right, your lordship. Citizen, your lordship, kindly glance the annex of the section 4. What says your lordship?
The Senior Citizen Act.
His grievance is that she is not coming in the definition of children.
That's right. And the children definition assuming you are already a daughter-in-law.
That is the pleading.
You are already a daughter-in-law. How can you claim that I am not a children here to protect the interest of the seniors in the house at least?
My response to that effect, your lordship. The another son is also with the opposite part number 3. Another son is there, your lordship.
Okay.
I am not the only daughter-in-law.
The house belongs to whom?
House belongs to the only the present deceased of the petitioner lordship. The husband of the present petitioner.
This is husband of the petitioner.
Yes, lordship.
It is not a house of the parent.
No, that is not the ancestral property of the present petitioner lordship. Petitioner's husband.
Come to definition chapter.
Lordship, that is 2A lordship, subclass A lordship. Lordship, may I read your lordship? Children includes son, daughter, grandson, and grandmother, but doesn't include a minor. Here.
No, therefore, there is probably some defect in the framing of the statute. How can it exclude the daughter-in-law?
But
suppose a son dies.
That
if the son dies, then the daughter-in-law steps into the property of the son.
Clarification.
So therefore, the dispute is in relation to the residence of the son.
Here,
so it's not your property.
That property is the self-required property of the present petitioner's
Now,
husband.
what has been directed by the original authority?
Your Lordship, kindly glance page. Relevant page is, Your Lordship, page 27.
Yes.
The imbue of second para. Imbue of the above observation.
Just 1 minute. Before that, please notify the fact. Let us know the fact.
Yes, Your Lordship. May I read, Your Lordship?
Come to page 45, place para 2.
Yes, Your Lordship. That 45 Honorable Court order, Your Lordship.
Page 25, the original court direction.
Yes, Your Lordship.
But I want to know what is the case there.
Yes, Lordship. The instance case, may I read, Your Lordship?
Second para.
Yes, Lordship. The allegation of the petitioner is that the PO is claiming herself as daughter-in-law, Bohu, of the petitioner and residing in the above residence. The son of the petitioners, namely Gopinath Sahu, died on 25/2014. After his death, the OP is claiming herself as the second wife of the Gopinath Sahu, who is the deceased son of the petitioners. Petitioners at that time the parents of the deceased husband of the petitioner. So the father, but only his mother is also OP number 3. The OP is forcibly staying in the house of the petitioners and drove out them from their residential house, for which the petitioners are pulling very miserable life, and they are residing in an abandoned wood cabin and depend upon the footpath for latrine purpose. The petitioner of the petitioners further speaks that the legal married wife of the deceased son of petitioners, Gopinath Sahu, namely Fakiramani Sahu, was a government servant who died leaving behind his only minor son, Shakti Prasad Sahu. After death of Fakiramani.
So this was application brought by the parents.
Yes, Your Lordship. At that time.
So you are the daughter-in-law.
Yes, Your Lordship.
So undisputedly the house belonged to the deceased husband.
Yes, Your Lordship.
Or the son here.
Yes, Your Lordship.
So there is dispute between the parent-in-law and the daughter-in-law.
Yes, Your Lordship.
So ultimately, what the authority directed?
Authority directed page 27. Since
come to page 27.
In view of the above observation and discussions, I am inclined to pass orders which are as under. First, since petitioners being senior citizen have the right to residence, so Purnamasi Mahapatra, present petitioner, OP is directed to provide a room to petitioners to enable them to lead a happy life.
Why are you not providing a room? Where they will go?
My responsibility, they have the
They have also a right over the son's property.
That I am not disputing now, but they
provide them one room. Why are you fighting all these litigation?
So far, itself from the bare reading of the statute is clearly says they have another son. The parents of the parent-in-law of the present petitioners have another son. They are not fighting against him.
No, they were residing here. You are troubling, therefore they have brought it.
That is the submission, Lordship. That petition, whatever I read in page 25.
Now that is also the observation of the original law.
Kindly glance. May I fact of the case, Your Lordship? May I permit the fact of the case, Your Lordship? Present petitioner husband.
You allege that since he has another son, he has a house. Why this parent-in-law not moving to that house?
Yes, Your Lordship.
No, that can't be your claim.
But here the statute clearly says
they have to decide where they will reside. They have to decide where they are to reside. Their parent, one is already in 84, one is 60. So
what happened? One of the difficulties.
Mr. Counsel, you are not understanding. One day you will also step into this situation.
So far statute as per the law, I have no more.
No, statute, there may not be well covering of the cases of these daughter-in-law, but that cannot be a stand here.
So far second.
Now this has been affirmed by the competent authority.
But that order was without affording an opportunity. The London SDM has passed that order. Therefore, earlier I have approached the Honorable High Court. Honorable High Court is against that order. I have also prefer writ appeal. Thereafter, after writ appeal, remanded the matter to alternate remedies there.
Now this order has come.
Yes, sir. That order, SDM order is not without in applying opportunity, Your Lordship. That order is in past. Inquiry is past. Your Lordship, kindly glass statute, Your Lordship. What is the provision? What is the process of inquiry, Your Lordship? That is page section 6, Your Lordship, clearly says.
The original proceeding was decided in your absence.
Yes, Your Lordship. Without making an inquiry, proper inquiry, Your Lordship. What happened?
That is a different aspect.
Yes, sir. In my
You
absence.
say it is, you are not given opportunity
Yes,
of hearing.
in my absence, Your Lordship.
In your absence,
Yes,
how do
Your
you establish that?
Your Lordship.
How do you establish that?
Statute clearly says so after passing.
Oh, don't go to statute. This is a factual allegation. You say you have not been provided with opportunity. How do you establish from the original
Before
order?
granting any direction, the Honorable SDM should have make an inquiry regarding the status of the parties and regarding the movable and immovable properties against the opposite party, Your Lordship. That SDM had not done in this case, Your Lordship.
Finally, come to page 26. Finally, in the instant case, hearing was made on 7/1/16 and on 28/1/16. During course of hearing, OP Purnamasi Mahapatra, the present petitioner, stated that petitioner Sukumari SAHOO, Kasinath SAHOO are creating problem in her family life time and again, for which there is a bad impact on her son who is transitional stage. So you have participated in the hearing.
Dear Lordship, I am participating.
So therefore it's not expiry order.
No, expiry, Your Lordship, I am not saying expiry order. But before granting and direction to give a residence and to financial help to the senior citizen, that should make an inquiry, Your Lordship.
Not necessary.
Clearly,
necessary. Inquiry is not always a necessity.
Section 6.
Yes. All right. I am not satisfied. This order has been confirmed in appeal. Yes, I am not satisfied. Give way to the senior citizens.
Let it become next week, Your Lordship.
Yes, give way or it's
judgment.
Listen.
Yes, Lordship.
Listen, if you find difficulty, you go out and have another house. So long as these people are surviving.
That property is not the ancillary property of the present daughter-in-law.
May not be. First right comes under the Maintenance of Welfare and Parents Senior Citizen Act, comes to the senior citizen. So you have to give way to them.
They are the substitute. They have another ancillary property.
Okay,
I am not claiming
go there, go stay in an outside house if they are creating, or you are not satisfied with their behavior. You find out your alternate situation.
Initially, the present opposite partner.
You have provided them accommodation or not as of now?
As of now, I have given the finance 1500 to the direction. I am paying regularly.
Provided the room or not? Provided the single room as directed or not?
Instruction Monday.
No, you should have taken that instruction. You should have taken that instruction. You don't have any stake at all in this act. Act is to facilitate the senior citizen. One is already in 84 years. Who knows how long he will be surviving? Yes.
So far, petition.
I am dismissing. I am not convinced with any of the grounds.
May I pray one thing, Lordship?
Yes.
Let it come any next week, Lordship. I have come with a judgment that I have the daughter-in-law have no the opposite part number 3. Here is the no locus standi to file any such application against a daughter.
I will not search for judgment as of now. This is the writ petition filed when? 29/3. You will search for judgment after when the case is placed in court.
Yesterday night I am feel unwell due to my.
Pardon?
ମୋ ଦେହ ଟିକେ ଗତକାଲି ରାତିରେ ଖରାପ ହେଇଗଲା
ନଥିଲେ ଆଜି କାଇଁ ଲିଷ୍ଟ କରୁଥିଲେ କାହିଁକି ଫାଇଲ କେମିତି କଲେ ଆଗ
I have given the grounds in my state
ଫାଇଲ କାହିଁକି କଲେ without searching decision in your favor? Listing of matter is not a real cell of a proceeding.
In my grounds I have taken in page number 10.
If you have taken a ground, then it should be well supported by a judgment also. Petitioner expresses its non-preparedness so far as the decision come to rescue of the petitioner. This court finds strange in the filing of the writ applications without endeavoring to find support of law to the petitioner. It's unfair on the part of the council to ask for going through judgment, supporting the case of the petitioner and seeking thereby adjournment of the matter. This court find the read petition was filed without proper preparation. And are dismissed as not is not in full preparation of the petitioner. However, liberty granted to file a fresh writ application with appropriate law, if any, in support of the petitioner. Yes, I am dismissing. You find out law, thereafter file.
Let it be Monday.
Let us stop this practice of filing. Let us stop this practice of filing. It is not just throwing a petition to the High Court. If you challenge two courts' order, then you should have come with the decision. Yes, it is dismissed.
So let it be next week, Lordship, Monday.
No, no. I have granted you liberty. You first prepare yourself, then file the case.
Impugned order, Lordship, can be permitted to substituted by way of
Impugned order herein for the dismissal of the writ application on technical ground, keeping in view the request for return of the same. Registry directed to return the same, but however keeping a Xerox copy of the same. Please don't file writ application unprepared.
Statute clearly says I am not to come with the other purview.
Next.
Item 3.
Obliged.
May I please, Lordship. Last occasion, Lordship directed my Lord senior to take instruction, my Lord. In this case, my Lord, I have completed the work, but no.
Yes, non-releasing of
Yes, instruction ta painu 24/4 ame magichu instruction ta asini 10 din hichi.
Place the matter. State Council submits, it is yet to get the instruction as per direction of this court dated 18/4/23. Place this matter after vacation.
Date, my Lord.
Instruction, if any, be obtained in the meantime.
Date. After vacation, date.
After vacation, date kar de. 17th of July.
My Lord.
Item 4.
Pendency of the writ application shall not stand on the way of the competent authority to release the amount in the event there is valid request pending before the authority. Yes.
May I please, my Lord? The present petitioner is a social worker, my Lord. Present petitioner is a social worker, my Lord.
Special worker.
Social worker.
Social worker.
My Lord.
My Lord, copy has not been served on me.
I have
Copy of
already sought copy, my Lord.
ଶୁଣନ୍ତୁ ଆପଣ ପ୍ରିଏମ୍ପ୍ଟ କରନ୍ତୁ ଆପଣ କାଇଁ ପ୍ରିଏମ୍ପ୍ଟ କରୁଛନ୍ତି ଯେ ମ୍ୟାଟରଟା
ନାଇଁ ସାର୍ ଖାଲି ଗୋଟେ ମୁଁ ଆପଣଙ୍କୁ ନଲେଜ
if you demand taking notice then I am admitting.
It's up to my lords.
No, you should not make that statement.
Sorry, my lord. I'm sorry.
You should not make that statement.
I'm sorry.
First, let me convince whether the matter is admissible or not. So please take your seat. Yes.
My Lord. Present petitioner is a social worker, my Lord.
What are you challenging here?
My Lord, I am praying for a suitable direction to the OP number 2 to registration my political party.
For registration of your party.
My Lord.
Is there any application pending?
Yes, my Lord. Annexure 5. Annexure 5.
Annexure 5.
Page 45.
Annexure 5 is a registered receipt only.
No,
okay,
my
5 series.
My representation.
5 series. A matter ta aguru asthila ki?
No, my Lord.
It's like this.
First time.
Who is the authority to grant registration? Who is the authority to grant registration?
Secretary Election Commission of India.
No, where from you go get that power? Go act achi provision dekhandu. It's a registration of a political party.
And Annexure 3, my Lord.
Oh, you are going to Annexure 3.
My Lord. Annexure 3.
What law prevailing here? What is the statute prevailing here?
Annexure 3, my Lord. The opposite party number 2. Issue a letter, my Lord, to the present petitioner. That is the application for registration of a Janashakti party.
Do you appreciate my query?
My Lord, under section.
Do you appreciate my query?
My lord,
ମୁଁ କଣ ପଚାରୁଛି ବୁଝିଲେ କି?
my lord, section.
କଣ ପଚାରିଲେ କୁହନ୍ତୁ?
My under which section?
Under which statute the registration of a political party comes in?
29A of the Registration of People Act 1951, my lord.
Okay, RP Act देखेलो. Section
29A of the Representation of the People Act 1951.
पढ़िले section 29A.
Correct. The registration of the election
Just
commission.
1 minute, 1 minute. Yes. पढ़ंतु.
My lord. 29
Registration of
with the election commission of association.
please
and
be on
public-
mic. आपण सियाडू कोने की पढ़ले माइक रहला याडे.
My lord. Registration with the election commission of association and the bodies as a political party. One, any association or a body of an individual citizen of India calling itself a political party and intending to avail itself of the provision of this part shall make an application to the election commission of for its registration as a political party for the purpose of this act. To my lord, every such application shall be made to my lord, if the association or a body is existence at the commencement of the representation of the.
So application will be filed to the election commission.
My lord.
For its registration.
My
Now
lord.
come to Annexure 5.
Annexure 4 is my application, my lord.
Annexure 4 page.
4 series.
Page.
Page 34.
34. No, the 34 appears to be checklist.
My lord.
Where is your application? Checklist seta.
A checklist. Annexure 3, my lord, page 32. First, my application, my lord. Annexure 2 is my application.
Application Annexure 2 or 4 kahin kohutandi?
Annexure 2.
So Annexure 2 was your application.
My lord.
Pursuant to that, they have also communicated you requiring some clarification.
My lord.
Now it is pending at their level.
My lord, pending, my lord.
Pending at their level.
My lord.
So a final decision ultimately to be taken by the election commission.
My lord.
Yes. What do you say now?
Lord, I have not received a
Okay, now
copy.
copy the, I'm disposing. It's a
Yes.
pending case, so therefore, beyond copy the.
My lord.
Copy already.
What I could-
Statement.
I have already
Keep.
sought copy to the state council, my lord.
State council is not relevant here.
Today I
State
have-
council, they don't have copy. They're not competent authority. Why should you serve copy on state? Out a copy null diyon them. See, their file create kar denani. Had the submission of council for the petitioner appearing to be a social organization in attempt to register it as a political organization. In such ambition, by Annexure 2, it appears petitioner has already made an application to the election commissioner under the provisions of section 29, capital A of the Representation of People Act 1951. By Annexure 4, it has been established. Annexure 3, right? It has been established that there has been already communication requiring certain clarifications to show progress in the request of the petitioner. By Annexure 4, it has been established there has been supplying of clarifications along with necessary documents since 28/18. Through the writ application, it is alleged even after such development, there has been no finality to such application. Keeping in view the innocuous request, this court and for the dispute still, for the claim still pending under the adjudication of Election Commission, this writ petition stand disposed with a direction to this. It a co-election commission. This can't be state election commission.
No, my OP number 2.
Huh?
Election commission.
You have made application to whom?
OP number 2.
OP number
2.
4.
Election commission.
Come to annexure 2.
2. OP number 2, my lord.
2.
My lord.
Come to annexure 2. It is addressed to whom?
OP number 1, my lord. Chief Election Commission of India.
Secretary Election Commission of India.
Chief
Then who-
Election Commission of
Then
India.
who is the opposite party here? Which opposite party will be directed?
OP number 1, my lord.
OP1.
Commission is to consider.
OP1.
Commission is to consider.
Huh?
Chief, OP1 is to consider.
Yes, OP1 is directed to give a lawful outcome to the request of the petitioner by annexure 1 by completing such exercise and in the involvement of the petitioner at least within a period of 3 months from the date of communication of order. With this observation, the writ petition stand concluded. Free copy of order be handed over to Sri Gopal Agrawal who has the instruction to appear for OP number 1.
If that application is pending, and 2018 application, so if such application.
In the event pendency of such application as of now.
Obliged.
Yes.
Item 5.
May I please, your lordship? No, on behalf of Mahanti, my lord.
Disposing
This is a case for mutation, my lord. I have filed the mutation.
2013 mutation case still pending.
Yes, my lord.
It is strange to observe mutation case 82 of 2013 is pending even after 10 years. While expressing its anxiety, this writ petition stand disposed. However, observing in the event there is no lawful obstruction in undertaking the lawful exercise involving mutation case 82 of 13, same may be given disposal by OP number?
OP number, my lord.
3.
3, my lord.
OP number 3, working it out at least within a period of 2 months, but however involving parties likely to be affected. Yes.
Item 6.
Item 6, early disposal of RP case pending for the commissioner consultation settlement.
Admission नहीं 2015
No,
matter.
no.
They are expressing its anxiety in even not admitting RP case 534 of 15. This court direct the OP number
2, my lord.
2.
My lord.
OP number 2 give a lawful disposal to the proceeding by annexure 1 by working it out at least within a period of 4 months from the date of communication of order, but however in the involvement of contesting parties. Yes.
Item 7.
May I please, your lords?
Yes.
The limited prayer of the petition, my lord, only to seeking a
Seek
direct
disposal of the RP case.
My lord.
Okay, notice subsequent hegalani RP case re.
Yes, my lord.
Reading already completed.
Yes, my lord. In the meantime, my lord, the matter has been transferred from the joint commissioner to secretary at this, my lord. So now this matter is pending before the
Okay,
opposite
but
party
it's
number
a
2.
2023 proceeding.
No, my lord, 17 proceeding.
17.
Renumber. Yes, my lord.
Or renumber.
Renumbered.
Okay. The writ petition involved the following prayer. Background involving the case is petitioner brought 15B of OSS Act proceeding in 2017 being registered as revision petition 683 of 17. Pleading discloses there has been transfer of such proceeding to the competent authority OP number
2, my lord.
2 presently.
Secretary to address, yes, my lord.
OP number 2, and there has been re-registration of the proceeding as RP 73 of 23. Okay, for finding the transfer of the proceeding to the OP number 2 recently. In the disposal of writ application, this court direct the OP number 2 to give lawful disposal to such thing, but in the involvement of the party likely to be affected, showing outcome at least within a period of 4 months from the date of communication of order.
Published, ma'am.
But so free copy the statement.
Item 8. Caveat ଦେଇଥିଲି ଆଜି receive କଲି copy ଟା Monday.
Yes.
I have filed a caveat, just now received the copy. Monday.
ସବୁ ଦି ଜଣ ଯାକ ମାଇକ ରୁ ବାହାରେ।
Caveat file କରିଥିଲି, copy I have just received. I pray Monday or Tuesday, my lord.
Caveat ର ରୋଲ କଣ? In the event court proceeds for interim order.
Yes.
ନା ନାଇଁ?
Here there is no.
So ଆପଣ ଯଦି କହିବେ ଆପଣ ସମୟ ମାଗିବେ ଆମେ admit କରିଦବା matter କୁ।
No. I
ଅସୁବିଧା
am the for the petitioner. I am challenging annexure 5. The order passed passed in the mutation appeal without giving me any opportunity. Your lordship may kindly see it from
This
the
is a
order.
mutation proceeding.
Mutation appeal.
Mutation appeal has
My
been
lord,
decided.
yes. My lord,
Mutation appeal has been decided in your absence.
yes. Your lordship may kindly see page 50.
So how do you establish that?
My lord, your lordship may appeal.
Come to the appeal order. Where do you find this has been decided behind
My
your
lord,
back?
there is nothing. Nowhere it has been stated who has been heard or not. My lord, I have filed the appeal on
This
21/9.
appeal was filed when?
Appeal was filed on 21/9/2021.
21/9.
2021.
21.
And 26/11/2021. It was order was passed.
And they're also involved with section 5 application.
Yes, I have also filed a petition for section 5, and it has been stated that the petitioner, your lordship may kindly turn to the last portion. In any case, it has been
So
stated.
delay has been condoned and matter has been decided then and there itself.
Yes.
Yes, what is there to be argued? Let the matter go back.
Monday the night.
Pending here, I will be staying the order. You will not be.
My lord, he is interested for his material instruction.
Subuni.
Material instruction.
ମୁଁ ଏ ରେଟ୍ ରେ କିଛି ଇଏ କରିନି, ସେଥିପାଇଁ Monday କହୁଥିଲି ଖାଲି।
ଆସୁ ସେ ତାର ପାଇ।
এটা কোন ম্যাটেরিয়াল ইনস্ট্রাকশন টা আজকালি ডিফিকল্ট হয়ে গেল কি লাইভ হয়ে যাচ্ছে বলি সে জানি ଯିବ রেজাল্ট আর আসিবনি
মে বি সেটা রিজন হই পারে
বর্তমান অবস্থায়
there is already appearance on behalf of the private counsel by way of caveat. There has been also service of copy of the application on the caveator. Your OP number?
My lord, OP number
କେତେ OP ମେଞ୍ଚେ OP ଅଛନ୍ତି
4 and 5 my lord.
4 and 5 herein. How so many OPs are there?
My lord, so many
ସବୁ ଭାଇ
ଭଉଣୀ, my lord, 2 suits are pending. 2 suits are pending.
No, in that even notice has to go to other.
My lord, your lordship may kindly bear with me for some time. My lord, one suit, one ex died, leaving behind his 5 daughters. 5 daughters, one of them filed a petition for partition. While the matter was pending, the nephew of that ex, his legal heirs filed a petition that the property has been gifted to his father, and some of it also has been gifted to her. Therefore, she filed a petition.
No, madam, make it clear whether other opposite parties have a contest in the matter or not.
Contest in the matter, your lordship, if matter will go back to the.
No, I can't pass ex parte again. You say it is ex parte, then I will be committing that mistake.
My lord.
Is it reasonable?
My lord.
Sorry.
My lord, the.
Notice ନିଅନ୍ତୁ ଅନ୍ୟମାନଙ୍କୁ stay କରିଦବା. What is that?
stay file କରୁନି, stay କରିଦେବେ ଯଦି ଭଲ।
Stay ତ ହବ ବାଧ୍ୟ।
ହଉ ଠିକ
Part of the appearance is there, so others are to appear.
ତାହେଲେ ସୋମବାର।
Yes, if you undertake to appear for others.
I will take my lord that on.
So you, in the meantime, you take instruction.
Your lordship may call
Okay,
him
this
on
court
Monday.
find there are number of contestants. Keeping in with the allegation, there has been disposal of the mutation appeal 14 of 21 behind back of the petitioner. And for the court finding, there are other contestants apart from the caveators already appeared. This court find matter the matter can be disposed of only after notice is sufficient on all contesting opposite parties. In the process, this court is inclined to issue notice.
ମୁଁ ତ ଇଏଟା ଫାଇଲ କରି
Requisites as undertaken by Tuesday. Matter be placed immediately after appearance of the other opposite parties.
my lord may I pray
Extra copies be served on State Council who will be appearing for OP number so and so so and so. In this case, a notice as above. In the meantime, there shall be stay of order at annexure 5 till next date.
मिसकेस से फाइल करना
मिसकेस
मिसकेस फाइल नहीं
मिस
मिसकेस फाइल है नहीं इंटरिम एप्लीकेशन फाइल है नहीं
फाइल है नहीं
नहीं
ମୁଁ ସେଇଥିପାଇଁ କହୁଥିଲି ମଣ୍ଡେ ଆସୁ
फाइल करिवे
आगे मंडे दिन आसले से फाइल कर दे मु भी इंस्ट्रक्शन नहीं आती आगे
କାହିଁକି ନା ସେ
ड्राफ्ट रख हला ड्राफ्ट रख खाली आज ऑर्डर करबो प्लेस द मैटर
on Monday
on Monday.
oblige
Draft रखबो. Yes.
Item 9.
May I please, your lordship? My representation is pending before OP number 3, my lord. A representation regarding.
But you seek quashing of annexure 2.
My lord, quashing of annexure 2 is.
Come to your prayer.
I am not pressing that.
You are not pressing.
My lord. It is appeal is lies against the. I am not pressing that.
To consider the appeal representation by annexure 5. So that representation is by way of appeal. So I am directing. Who will be directing? OP3.
The
OP3.
OP3. The Jharsuguda Improvement Trust is the authority to decide. Take Jharsuguda Improvement Trust is the authority to decide.
OP number?
OP number 3, my lord.
Okay, I am directing. Yes, petition has the following prayer. Undisputedly, a statutory appeal is pending before the by annexure 5. Is pending before the competent authority. OP number
3, my lord.
3.
My lord.
Okay, keeping in view innocuous request, this court disposes the writ application directing OP number 3 to find a lawful disposal to the appeal of the petitioner by annexure 5. Also providing opportunity of hearing to the petitioner.
In view of the annexure 4, my lord.
Keeping, okay, in the involvement of the petitioner, at least within a period of 3 months, while also keeping in view the development through annexure 3.
Annexure 4, my lord, there is the director, letter is the director, my lord.
Okay.
Certain observations are made.
Let the petitioner supply the copy of writ application along with the documents enclosed therein to the OP number 3 within a period of 7 days.
My lord, oblige.
Item 10.
May I please, Lord?
Yes.
My lord, though I am challenging annexure 1, but your lordship can take annexure 3 first.
It is oil company.
My lord, that is Mahindra and Mahindra, that tractor manufacturing company.
So termination of dealership by whom?
By the, your lordship will say annexure 1, page 13.
By whom? OP number?
By opposite party number 2, my lord.
2.
Yes.
If a REIT is entertainable.
Mahindra and Mahindra, my lord, that is a multinational.
Mahindra is a private entity.
Oh, the government of India has undertaken.
Oh, no, sorry. Mahindra, Tata, since when they have become a state authority?
No,
Mahindra is also industrialist.
My lord, that
private industry, not a public sector. So therefore, go for appropriate proceeding. No REIT court can entertain. Say dealership, maybe violation of or in terms of the agreement. These are contractual obligations.
The contractual obligation, that's why I am saying.
Contractual obligation है आपन REIT court को आस्पेरिवे नहीं.
Annexure 3 टे देखो ना. Annexure 3. Annexure 3 रे से clearly लिखिचंती जे हमर 31 मार्च.
ये लिखिला.
Company लिखिला.
Company is a public sector or private sector?
That I have examined that Mahindra and Mahindra, that is have since the government has share in it.
Sorry. Then ताल तो आउ रही बनी किसी. ताल तो सबू टाटा, अदानी, अंबानी, जहाँ सबू ही जीवे समस्तंकर गवर्नमेंट शेयर अच्छी, समस्ते पब्लिक सेक्टर बैंक रू लोन नहीं चंदी. Sorry, withdraw karo to not dismiss karbi. It's not entertainable. Withdraw to pursue appropriate remedy. ଆପଣଙ୍କର ଯଦି agreement ରେ ଅଛି arbitration, you may go for arbitration.
ସେଇଟା ନାହିଁ ବୋଲି
ନାଇଁ
ମୁଁ
ଗୋଟେ
ଅଛି।
agreement ରେ definitely ଗୋଟେ condition ଥିବ ଯେ court କୋଉ jurisdiction ରେ decide ହବ. There must be some
ସେଥିରେ ସେ
agreement.
ଲେଖିଛନ୍ତି ପଞ୍ଜାବ ବୋଲି ଏଗ୍ରିମେଣ୍ଟରେ ସେ ଲେଟର ଅଫ ଇଣ୍ଟେଣ୍ଟରେ ଲେଖିଛନ୍ତି ପଞ୍ଜାବ।
ପଞ୍ଜାବ ଯିବେ
ଆମେ ସବୁ
ପଞ୍ଜାବ ଯିବେ ନାଇଁ ଯଦି ଆପଣ ଓଡିଶାରେ ସଫରିଂ କରୁଛନ୍ତି ସୁପ୍ରିମକୋର୍ଟ ଯାଇ କହିବେ ଆଜ୍ଞା ମୁଁ ଓଡିଆ ଲୋକ ମୁଁ ଏଠି କରିବି ଓଡିଶାକୁ ଟ୍ରାନ୍ସଫର କରିଦିଅନ୍ତୁ ସେ ହେଇପାରିବ that's a possibility so no writ entertainable for the cause of action involving OP number 2 completely a private
my lord
body.
must say that I will pursue my remedy so let it be withdrawn.
Okay, counsel for the
dismissal with
seeks withdrawal of the writ application to pursue his remedy before available authority. Allow with this observation, the writ petition is permitted to withdraw. Please don't file such litigation. ଆପଣ 1000 ଟଙ୍କା ନେଇ ଯାଉନାହାନ୍ତି ନାଇଁ ଆପଣଙ୍କର ଫିଜ୍ ବହୁତ ଓପିନିଅନ ଦବାରେ 5000 ନେଇଯିବେ କହିବେ ନାଇଁ ବାବୁ ଏଠି ହବନି ଚାଲ ପଞ୍ଜାବ ଯିବା ସେଠି ଫାଇଲ କରିବା କାହିଁ ତାକୁ ଫସଉ କ୍ଲାଏଣ୍ଟ ଏ କଥା ଯଦି ଶୁଣୁଥିବ ଯେ ଆରେ ଜୁରିସଡିକ୍ସନ
ସେଇ କଥାଟା ମୁଁ ଅଲରେଡି କହିସାରିଛି
କଥା ଲାଇଭ ହେଇଗଲାଣି ଟିକେ କେୟାରଫୁଲ ରୁହନ୍ତୁ ସମସ୍ତେ
ନାଇଁ ସେଟା ମୁଁ କହିସାରିଛି
ହଁ yes next
Item 11. My lord, item 11 on behalf of Vidyut Chana, Monday, my lord.
OPL matter.
OPL हाँ ये settlement अच्छी OPL पढ़ेगा अन्य कोर्ट को पढ़ेगा you are getting adjournment otherwise matter involves provisions of OPL Act. This court doesn't appreciate listing of such matter in this court. Registry directed to find out the assignment and list it accordingly.
Item 12.
May I please your attention?
Yes.
This is the matter in which the unemployed young men have taken the pisciculture of prawn cultivation at the area of Raskanika, Kendrapada.
Why? What is your application before the Tahsildar?
That they have given a notice that you should demolish the.
So opposite jiba ପାଇଁ କହୁଛନ୍ତି ଆପଣଙ୍କୁ eviction virtual eviction
ଆଜ୍ଞା.
direction.
Yes,
So ଆପଣ response ତ NSO 4 ରେ ଦେଇଛନ୍ତି.
ଆଜ୍ଞା.
Then why have you come to High Court?
Because they have given the second notice to on 29th. It was
Where is
received
that?
later on.
Where is that?
It has received to yesterday only before.
ଆଉ କାଗଜ ବଢେଇଲେ ମୁଁ କଣ କରିବି?
Second notice has been served that they
So
were demolished.
you need to amend the writ petition.
Millard, it has to be stayed because the demolition has to be.
No. Unless you bring it within the forum of consideration, I can't take cognizance of such document.
Millard, I have already filed Annexure 4 in 3 that they have already stated that.
If you go to Annexure 4, it's an objection pursuant to Annexure 3 notice.
Yes, Millard.
Okay.
Yes,
Therefore, I can give a direction for consideration. But now you are showing there is further direction. There was an earlier writ also. And maybe division course judgment is being implemented here.
Millard, yesterday, similar matter has been disposed of before this honorable court and a stay.
Which court?
In this court number 22, Millard, before your lordship, that is number is 13,816.
No, I can't dispose such matter.
Yes,
all right, you bring it by way of amendment, then only I will consider.
Millard, it will by that time they will demolish.
Even though the case involves tendency of consideration of objection of the petitioner pursuant to notice at Annexure 3, in the course of hearing, Mrs. Kiran Raut, learned counsel appearing for the petitioner, brings further development by way of issuing a further notice. To the notice of the court, this court find difficulty in entertaining such aspect. Counsel for the petitioner, if wants to involve such issue, may bring an amendment to the writ application. Place the matter Tuesday along with amendment application, if any.
I may be pardoned, Millard. By that time, if this honorable court may give a direction to consider the Annexure 4, Millard, then that will also help. I have made representation.
Pardon?
Annexer 4, as I have placed representation before the Tahsildar, if this honorable court will graciously please to consider give a
So
direction.
I
to
can
consider.
give a direction provided the issue is still surviving.
Yes, Miller. If today I'll get the certified copy and by fax I will send it to
But
the
you are producing something, it appears that is probably final decision. Why are you running risk? Anantu amendment, Anantu further plea diyontu that the proceeding is still pending, then I'll pass order.
Miller, if by that time I will come to the
Oh, yes, that is not my issue.
representation may kindly be
If you
considered.
got it, why you should have come with amendment application.
The annexer
I
4,
don't mind in disposing. I can give a direction provided the proceeding is still surviving.
yes, it is still surviving, Miller.
Okay, all right, dear, dispose karta. It is at this stage of the matter, learned counsel appearing for the petitioner. Praise this court for at least a direction to the Tahsildar Kanika, UP number so and so, for giving a lawful disposal to the notice at annexure 3, while also keeping in view the response of the petitioner by annexure 4. By annexure 4. Okay. This court here records the submission of Mrs. Raut that the proceeding by annexure 3 is still pending adjudication. This court observed in the event the proceeding by annexure 3 is still pending adjudication. Nothing prevents the Tahsildar in giving a lawful disposal to such notice, while also keeping in view the response of the petitioner by annexure 4. Is with this direction the matter stand disposed.
Item 13.
urgent certified copy, Miller.
Oh, yes.
Highly obliged.
Urgent copy and proper application. Yes.
May I please, Your Honor? My lord, my demarcation application is pending before the OP number 3.
Is it registered?
No, my lord. 1.5 month has already passed, not registered, my lord. 1.5 month has already passed, not registered the case, demarcation case.
Where is that order?
Page 11, my lord.
Page 11.
My lord.
Page 11, your application there.
Yes, my lord.
Oh, that is still pending.
Yes.
But this is no application in the eye of law.
No, my lord.
There is a format for demarcation and there is a due.
I am tagged with the application, but it is my representation, my lord. Huh? It is my representation. I have already.
No representation is permissible.
Right. Form ta mu tag karichi ase to.
Kain form kain?
Form ta.
Form kain? Deposit kain?
Deposit ta.
ଦେଖନ୍ତୁ ଆପଣ ମହକିଲ ସେଠି ଦେଖୁଥିବ ଆପଣ କଣ ଫାଇଲ କରୁଛନ୍ତି ତ ଲାଞ୍ଜ ଯାଇକି ପଳେଇବେ. If you bring a proper application, it will be considered. Withdraw this. Representation will not be entertained.
Oblige, my lord.
Yes, Krishna wants to withdraw the writ application with a leave to file, bring proper application format with statutory dues required therein before the Tahsildar shall approve. Okay, with this liberty, the writ petition stand withdrawn. Yes.
Item 14. My lord, annexure 2 is the.
Yeah, please.
14. Yes, 14. 14.
May I please, Your Lordship?
Yes.
Lord, in this application, the petitioner has prayed for a direction for speedy disposal of election petition number 1 of 20.
Who are you? You are the return candidate or failure candidate?
Well, I am the failure candidate.
You are the election petitioner then.
My lord.
So why the case is not being disposed?
Lord, OP number 3 has appeared, that is there for the filing of the counter by the respondents. The
They are not
pending
filing?
since, no, my lord, 15th March 2022, since it is pending. Last order was on 28.
Prayer. All right. Election dispute was brought before the civil judge, Junior Division Mohana, on 15/3/22, registered as election petition 1 of 22. Scanning through the entire order sheet filed by the petition, order sheet involving the proceeding involved herein, this court find there has been already the case has already seen almost 49 dates. Up to 28/11/22. तापर कौन हला?
No instruction.
In the meantime, there is again lapse of almost 5 months time. In the meantime, counter has been brought or not?
But we have no instruction.
Then how could you file this writ petition?
My lord, counter not filed.
Huh?
Counter has not been.
Opposite party,
Be on mind.
opposite party, counter not filed.
As of now, there is no counter.
No counter.
As a coach, no instruction. Yes, this court records the submission of learned counsel appearing for the petitioner. Even as of now, there is no filing of counter to the election dispute. This court finds strange in the attitude of the civil judge junior division, the election tribunal, in giving so much leniency to the return candidate while expressing its anxiety in the manner of dealing with election dispute more particularly. This court observes, and this court direct the civil judge junior division, Mohana, to seek filing of the counter at least within a period 7 days of the date of receipt of the order, and to see final outcome in such proceeding at least within a period of 3 months. Hello, yes. With this observation, the petition stand disposed.
Lovely.
Yes. Administrative side रे चिट्ठी लिखि दो ना कहीं. Administrative judge को complain कर देवे आगे 49टा डेट गलानी election test रे ग्राम पंचायत election dispute रे counter file करना दी. Court goes on accommodating. Cost भी नहीं. प्रथम accommodation रे 50 टका cost करता है. तापरे 500, तापरे 5000, तापरे 5 लक्ष. देखिवा किन से counter देई न थांदा. आपको वकील भी से देखुची प्रत्येक तारीख रे टंका सकाळु 500 कि 1000 चली आछी.
Item 15.
अरे CPC procedure is applicable. सेते लेखा है जी. देखंतु GP Act रे section 31 रे पढंतु 37 को जानतु. Section 37 कोन लिखला देखंतु.
Power of civil judge junior division.
ना ते माइक क्या करे.
Power of civil judge junior division.
हाँ.
The civil judge junior division shall have the power which are vested in a court under the Code of Civil Procedure. When
So Code of Civil Procedure written statement रो filing रो procedure अछि ना नहीं.
My lord.
Order it रे.
My lord.
अछि ना नहीं.
My lord.
केते दिन कहला amendment दे करी written statement file हबो. CPC जानना है. CPC जानना है. There is already time stipulation by way of amendment in CPC. So say vitere jodi no file la expect hijibo. Neither your counsel there is aware of such provision, nor you are aware. And client ultimately suffers for having a poor counsel. बुझी पाले तो जिनस कोठी अटकीची. So आपन को counsel को पचारंतु कि कौन करूचंदी CPC रो प्रोविजन काहे कि सेठी प्रेस करूनांती. ये बतन लाइव हेलारु बतन लॉ स्टूडेंट भी खोल की बसी गलेनी. लॉ ट्रेनर्स भी खोल की बसी लेनी. कौन कोर्ट रे डिस्कशन होउची. तो आपन को स्टैंडर्ड गोस टू आउट. हला टिके केयरफुल रहंतु. आपन का आर्गुमेंट आरंभ होबा कथा आगे देखंतु ऑर्डर रेट रे कोन कहला रिटन स्टेटमेंट केबे फाइल होबो. सुप्रीम कोर्ट डिसीजन कोन हेलानी देखंतु केमती से एडजमेंट करूछंदी. पाठ पढ़ातु जदि मैजिस्ट्रेट कर बुद्धि नहीं मैजिस्ट्रेट को नहीं से प्रोविजन ता पढ़ातु. CPC एप्लीकेबल. CPC कोन कहूची. Yes.
Next.
My lord,
Yes,
here
next,
the
next.
order under annexure 1, page 16 is under challenge, my lord.
This is item 16, na?
Item 15.
15.
15, sorry. Yes, 15.
Page
कौन
6
challenge करछन्ते?
Page 16, the order rejecting my application for permission to sell. The petitioner is the man belongs to scheduled caste.
Application to sell.
Application to sell his property under
Sell
section
property
22.
section 22.
Yes, my lord.
Then appeal lies. OLR Act dharantu. Section 48. 58. Section 58 पढ़ंतु.
मैंने any person aggrieved by an order passed any.
ସେଥିରେ 22 ଧାରା ଅଛି କି ନାହିଁ ଦେଖନ୍ତୁ. ଅଛି କାହିଁ ଆପଣ ତା କ୍ଲାଏଣ୍ଟ କୁ କହିଲେ ହାଇକୋର୍ଟ କୁ ଆସିବାକୁ. ହେଲା ଲାଇଭ ଷ୍ଟ୍ରିମିଂ ଟା ଆପଣ ମାନଙ୍କୁ ପୁରା ଥୋଇଦବ ନେଇକିରି କୋଉଠି କହିଲେ ରାସ୍ତାରେ. ପୁରା ରାସ୍ତାରେ ଥୋଇଦବ to pursue appeal remedy. In the event an appeal is brought within 2 weeks, same shall be entertained and decided on its own merit.
By condoning the delay. Delay.
अरे बाबू मु जेतोले कहली 2 weeks रे appeal आनिबे merit रे decide अब आउ किसी दरकार अछि
नहीं आगु दरकार
आपको 2 weeks time देई देली. So no question मु जदी कहितांती along with a limitation petition, then I will say delay will be condoned and matter will be decided.
I'm sorry, I could not follow.
आ जमा तर्जमा करंतुनी लाइव होउची आज्ञा.
Item 16.
May please, my lords. My lords, in this case, I have challenged the impugn order under Annexure 8.
Annexure?
Annexure 8.
8.
My lord.
What is that?
My lord, I have filed an interim application during the pendency of the election case, my lord. That is
This is the interlocutory order involving election dispute.
My lord.
Interlocutory to the extent
to produce some relevant documents, that is voting papers, etc., my lord. Evidence has already been adduced and that has already been closed, my lord.
Okay.
And during the evidence, my lord, we have the present petitioner has found there is some irregularities in the counting and the recounting also, my lord. Therefore, I have filed the interim application and which has been dealt and that has been rejected, my lord. Against that, I have come. If the
evidence is already closed.
Yes, my lord.
So let us see your application.
My lord. Application is at
Annexure 7.
Annexure 7, my lord, page 34.
Yes,
134, sorry.
What is your prayer there? Let us see.
My lord.
Come to prayer directly.
My lord. Hence, it is prayed that your honor may be pleased to allow this petition and direct the opposite party number 2 to produce the following listed documents of the materials which have in their custody for proper inspection and pass orders for recounting all the ballot papers of Sarpanch.
So this is prior hearing is not permissible. It is only on the commencement of hearing. On the basis of the evidence, if the court feels it appropriate to go for a recounting,
my lord,
then only such a petition will
my
be
lord. I will appraise, my lord. My lord, kindly go through the evidence and which I have.
No, this you answer on the stage. There is already Supreme Court decision. My decision is also there. What is the stage in bringing such application? Merely on completion of evidence or in the course of argument? Because the
argument has not been started.
Argument, yes, undisputedly. Therefore, this is no stage. Therefore, this is no stage. See, in the course of argument, there must be framing of issue, whether this case needs a recounting. Come to issues. Where is the issue?
I have not filed the entire
issue definitely got a issue heitiva whether this is a fit case to go for recounting. then the court has to reach to that stage. Then court has a pause in delivering the judgment. And then court will direct what are the material to be produced based on the evidence.
My lord, I am apprehending that they may doing some mischief.
You go for argue, I will keep this application reserved. This you may, if it is necessary,
My lord.
you may move such application at that point of time, not at this time. There is right rejection. He has also come to that holding
My lord.
that this is premature. Hearing has not
My
commenced.
lord.
So you withdraw, and I will give you liberty to bring such application at appropriate stage. Yes, in the course of hearing, then counsel for the petitioner for admitted situation that there has been no commencement of the argument, wants to withdraw the writ application, however, with liberty to pursue such remedy in the event of any necessity at appropriate stage. Okay, this court find there is a genuine request, considers withdrawal of the writ application, but however, with the liberty as spread for. Law ta padantu, ta upare law settle hisarchi.
I have gone through the
Recounting re very rigid procedure.
My lord, I have gone through the judgment, my lord. And
Item 17, may I please?
Okay, in the event, yes, in the event, any such application is considered at later stage, the observation, if any, in the impugned order shall have no influence. Yes, yeah, next.
May I please? Annexure 2 is, Annexure 1 is pending before opposite party number 2, your lordship may direct. to
आपनकर
consider.
बेल थाको कौन सरियो लगी आपण रीट रे थिले आपण रीट रु क्रिमिनल को गले ना क्रिमिनल रु तहसीलदार को पळेलेनी
Annexure 1 pending before opposite party number 2.
Annexure 1 टा कोन पे पेंडिंग अछि
एटा दिया हितला सब विलेजर देइथिले, there is a dispute, my lord,
pending before
Tahsildar.
all right, prayer quote कर दो. Considering the pendency of the representation by Annexure 1 before the Tahsildar Tangi, this court feels it appropriate to dispose the writ petition, directing the Tahsildar Tangi to give a lawful disposal to such proceedings in the involvement of party likely to be affected, bringing in an outcome at least within a period of 2 months of the date of communication of order. Free copy of order.
Oblige. Item 18.
May I please, my lord? My lord, I faced a criminal prosecution way back in 2013, my lord.
Pardon?
I faced a criminal prosecution way back in 2013 for offences under the Prevention of Corruption Act, my lord. 2018, it ended with a judgment in my favor wherein I was acquitted of all the charges.
Acquitted?
Yes, my lord. Subsequently, my lord, your lordship would see under Annexure 4, at the time of investigation, my service book was seized by the CBI. Annexure 4, my lord, at page 41.
Page?
41.
41.
At the time of investigation, the seizure, my service book was seized by the CBI. After the acquittal, Annexure 4 is written by my department to the CBI, my lord, Superintendent of Police.
Just 1 minute. Annexure 4?
Page 41.
Yes.
Yes, my lord.
Yes, what happened there?
Subject is return of service documents of Chittaranjan South, the present petitioner, my lord. As per the judgment order dated so and so, he has been acquitted. Now, second last paragraph, it is requested to kindly return his service book so that his yearly increment, leave, etc. can be granted. But in the absence of service book, my lord, my promotions have not been have been withheld. My leave encashment has been withheld.
So there is a pending appeal.
Now, your lordship would see Annexure 5. Annexure 5 is the letter of the CBI.
Yes.
Wherein they state that the service book cannot be returned because it is a part of the appeal, my lord, and it is, so therefore it cannot be returned. My lord, the service book which was seized, it was neither required for any investigation purpose. Now, my lord,
why don't you approach the appellate court for returning the
appellate court, till date, the appeal has not been admitted. Now, my lord, I'm relying on the judgment of Kerala High Court, wherein the Honorable High Court has held in under the powers of under Article 226, the authority, when they don't require the service book, my lord, they should return it to the department.
No, in that event, I am to involve the opposite party. Take notice then.
Yes, my lord.
Issue
But I only
notice on
pray, my lord,
discharge.
recently I've undergone a spine surgery.
Pardon?
Recently I've undergone a spine surgery, my lord. I'm badly in need of money. So therefore,
Hmm.
I'm badly in requirement of financial benefits, my lord. Therefore, only a short date if after vacation.
Short date only after vacation.
Yes, sir.
Requisites be filed as undertaken by Tuesday. Notice be issued to the opposite parties. ये तो रेलवे appear करेगा.
CBI, I've already served copies on both the parties. my lord.
Other it OP 1 2 ऊपर copy service कर दे.
कर दीजिए क्या?
Okay, 3 ऊपर notice हुआ. No, extra copy देवे by way of
3 also, I think, my lord, Union of
extra
India.
copies कर दे.
I'll
3
serve extra
ऊपर
copy.
notice हुआ.
Okay. The notice, my lord, I think for 3 also, Union of India is receiving copies, my lord. For railways also, the Union of India is receiving copies, my lord.
Sorry, बुझेलानी.
Mugli, for railways also, Union of India is receiving copies.
No,
What is the
no, we don't
the Office
know.
of Solicitor.
You serve them.
Yes, my lord.
You serve them. If they accept, then file a memo that they have accepted.
Yes,
for
my lord, I'll
this.
do that.
Yeah, sometimes it happens, the notice is served, but nobody is coming to court. It is better you
Yes,
take
but
notice.
it's better I'll take notice by
Yes,
post. my lord.
notice on OP number 3. Matter may be listed immediately after service of notice, preferably on 12th of July. Yes.
Grateful.
Item 19.
Just 1 minute, Mr. Rai. This is a case involving return of service book. For updating the service book, keeping in view the acquittal of the petitioner in the criminal proceeding. Allegation: reason for non-return of the service book appears to be pendency of an appeal. Sri Roy, counsel appearing for the petitioner, brings to the notice of the court a decision by so and so, Chitrachela, and establishes even a read court in exercise of power under Article 226 of Constitution of India. Direct for return of service book if it is not a relevant material to be kept on hold till decision in the appeal. Sri Rai also submits, even as on date, there has been no admission of the appeal. This court finds strength in the submission of Sri Rai, direct for notice. Consequently, yes. Let me indicate so that it goes to some other court, then he can pick up the point immediately. Yes.
Regarding item number 19, minor, A form quota has been issued in favor of the petitioner. A form quota has been issued in favor of the petitioner, which has been annexed. K form, annexed on.
The copy of order. Covered over. Next.
Item 20.
Item 20, Lordship.
Mr. SAHOO, Mr. Ghosh, Mr. Mishra. Aji moro bodhe 10टा matter eithire galani. Jodi K form heichi loko kahinki High Court ko asibe. Jodi mutation case pending achi loko kahinki High Court ko asibe. Unnecessary wastage of time. I am spending some time to find out a check. Is next. Even जो दिन कॉपी दौचंती से दिन तो चिठी टे पठेई दियंतु काई सरनांती कोन रीजन अछि.
Now we have started writing letters, even simply disposal. संगे संगे में चिट्ठी कर दूचु जे करंतु एयर डायरेक्शन
dispose करो,
carry out करो, comply करो बोले हम पठेई दूचु.
dispose करो, provided there is no lawful obstruction. नहीं यदि कोन lawful obstruction अछि, then intimate us.
That I was talking with Mr. SAHOO today morning.
करो सुनतो आपण माने you may not be always the counsel in state.
Yes.
But create a precedent.
Yes. Lordship, Lordship, Annexure 1, Lordship, kindly receive this case. Running page 22. In the year 2010, Lordship, a decision was taken by the
in presence of the sub-collector to construct a panchayat house in a particular land, lordship, that is plot number 142, lordship. Page 22, lordship.
First answer karantu.
Lordship.
आपण माने कोन मते इत्ते डरी गले जे ए वर्ष क्रिकेट खेल करई देलेनी.
Lordship, in fact, we tried our best, but annexure 1, page 22, because now many lordship, the writ applications are before the Hon'Ble court, and your lordship remind this matter, now stage has come, whether a gram panchayat can be constructed in a gochor land and also in a presence of a Jolashay, lordship, in a river, sorry, in a pond. Lordship, kindly come to annexure 1 for a moment, annexure 1.
Yes.
Page 22, in there 10, lordship, in presence of the sub-collector, a decision was taken to construct a gram panchayat office over plot number 142. Lordship, kindly see this page 22.
Yes, page 22,
142. And lordship, adjacent to 142, there is another plot that is 156. Both are adjacent, 142 and 156. And lordship, kindly see the next annexure. Just I'll go to next page, lordship. Page 23.
Nilam hela.
Item 9, Jari Pokhori, Juda 142. In fact, that is a pond itself, lordship. The panchayat is given lease for that purpose, lordship.
What is this auction?
Auction, lordship, the panchayat.
Jolashay,
Serial 9, the Jari Pokhori, lordship, that is Jari Pokhori. That is a pond. And lordship, kindly see, because he.
No, how do reconcile? This is the plot number 1.
But lordship, in fact, lordship, kindly just now refer a document. Just now today, I just 20 minutes back, I got that document. On 17/2/2023, lordship, kindly see. This Tahsildar has, lordship, kindly to last page or first any page, lordship.
But it is recorded as Puratana Patita.
But lordship, kindly 27 this order, the observation of the Tahsildar. Lordship, just second paragraph. Plot number 304 and plot number 1 recorded at Anavadi Khata. Number 2013 is River Kisam and cannot be used for development purpose. Plot number 142, this is recorded as Kisam Puratan Patita in Anavadi Khata number 213. However, one pond has been excavated around 30-40 years back in the land, and the same is auctioned by from the Panchayat office. Plot number 30. So this is the administrative ground.
What is the progress now?
Now, lordship, they have constructed.
You have all registered.
Lordship.
Page 29, you have all registered.
Lordship.
What happened to that? Your grievance petition was there.
No, but lordship, what I pray, lordship, we are now all are the elected members of the Gram Panchayat, lordship. 9 ward members and Sarpanch himself, herself, and
they are the petitioners. They are the petitioners.
Lordship, all have come before lordship. Now we want to construct a Gram Panchayat office in an independent site because they are constructing a gochor land and with the available of only 5 decibel of land. And
Is there any direction for construction?
No, there is no, but one direction was given. Lordship, kindly come to page annexure 6, lordship, kindly. The page 34, lordship, kindly see page 34. This is because this inquiry has been conducted pursuant to lordship's direction. Lordship, just page 34, I'm reading the para 3, lordship.
Yes.
Point number 1. The Tahsildar Konasa letter number such has reported that after due inquiry in this matter, the construction of GP office Gada Balabhadrapur GP has been started over Khata number covering such and such. So such inquiry by Tahsildar Konasa was reported.
What is the position now?
Now, Lord, it has been because of the 35 lakhs have been allotted. Only they have constructed by investing previous Sarpanch. 5 lakhs has been invested so far the gochor land is concerned. Now it has been steered by your lordship's direction that is no development has been done since last 4 years, lordship. Now, lordship, the collector has given direction. You constructed in accordance with law. It is very confusing order. If the gochor is there, lordship, we cannot construct there, lordship. So there must be some appropriate order by the collector. A lordship, kindly see last then 2 paragraphs is very important, lordship. Why we have come here, lordship?
All right. Why you are working against the whim of the elected representative?
Madam, kindly see the annexure 8.
No, sometimes it appears from the report it is a pond there. Sometimes it appears it's a Anavadi land. So question is whether you will go by the interest of the villagers or being an administrator, collector.
No, this is the inquiry report given by the collector in page 38.
No, I'll give a direction for joint inquiry.
Yes.
You submit a joint inquiry report to as to find whether there appears a pond there or not.
Yes, yes.
Lordship, only one, page 34, Lordship, kindly see, because earlier there, the direction, the Sarpanch was the party to the committee, Lordship, kindly see, page 34, point number 2 and 3.
Yes.
Point, Lord, this is the point 2 is the report of the BDO, Lordship. The land on which GP office building will be constructed, it is situated at the end of the Balabhadrapur village, Balabhadrapur, and adjacent to the village pond and river Malaguni. The land is connected by a narrow approach road by communication regarding benefit of GP office for inhabitants. GP more than 4 inhabitants are objecting with the representation which is submitted to the BDO Kona such and such. Point number 3 is very important.
And had the submission of Sri Dole and counsel for the petitioner through variety of document, including even the observation at page 34. Through point number 1, 2, 3, Sri Dole attempted to at least prima facie satisfy that there appears a pond, village pond, which will be going to be affected in the construction of the GP building. Over plot number 142.
142.
Over plot number 142, khata number 214. Okay, this court find prima facie case to be examined, directing issuing notice. This case retracker to find a absolute resolve to the issue involved herein. This court, while directing the opposite parties to file their detailed counter, also direct the collector to have an on-spot inquiry in the involvement of the ward members involved herein.
Elected bodies, Lordship.
Hello.
Elected bodies.
Elected ward members of the involved herein, and submit the report on the next date of posting. Let's list this matter on 20th of July. Okay, Miss Kesri issue notice. One said, in the meantime, there shall be no further construction of the Gram Panchayat building till next date.
Inquiry was conducted in presence of the
Yes, that
Sarpanch.
Aरे सुनो सरपंच एकला आपन को सपोखे रही जाइतबो
No. Even if
आपन खाली बाहर कर दियंतु सेठी पोखरी अछि कि नै. One is पोखरी, and another observation I find there is very narrow strip of passage.
This is the finding.
So panchayat officer building देखो ना आपन करूना जदी their submission is wrong, we may vacate the order. What is there?
Joint inquiry हेई के report हेई page 38 रे.
Mr. Sahu, you have to understand why 11 elected members will come to High Court unless there is a case. Here there may not be any personal interest. 11 ward member आसिन केतेटा वार्ड रहिला कहले से पंचायत सरपंच पाखरे 14टा आइदिबो कि 12टा आइदिबो
13 wards 13 वार्ड रो
11 जण आसिलेनी अदालत को. So 11 जण को रिप्रेजेंटेटिव केते हेलेनी. So ultimately, whims of the administrator or the whims of the wish of the villagers. Yes, next.
Item 21.
May I please your lordship? The petitioner paid the premium to the conversion cases.
Pardon?
Petitioner paid the premium as per the direction of the Tahsildar for conversion of the land in question, but a record of right has not been issued.
There is already order for conversion.
Yes, my lord, I have already paid the amount under Annexure 2 series.
Where is that? Annexure
2 series, your lordship.
Page
2 series.
Page konto?
Page 2.
8 onwards. 8.
Again.
Then where is the order converting?
That order is not here with my lord.
Achi apon pakhare achi ki yanto to?
Mo pakhare nahi.
A kahi collect no kari file kahi kar douchon?
पैसा वाला दे दीजन.
How to establish this is conversion fee?
तले लेखा है जी fee type ता मधुर लेखा है जी fees paid.
Area applied for conversion.
My lord.
Let through Annexure 2 series, page 8, commencing from page 8. Counsel for the petitioner establishes that dependent on order for conversion. There has already been deposit of conversion fee. It is thus alleged, even after deposit of conversion fee, there has been no bringing in of corrected record of right. After involving the submission of SAHOO, landed AC, this court disposes the writ application observing. In the event there is already order for conversion of the disputed land, and there has been deposit by unnecessary 2 series, page 8. The Tahsildar OP number so and so shall bring the corrected record of right forthwith. With this observation, the petition stand disposed. Free copy of order be handed over. Forthwith na kariye, within 1 month kar diyo. Yes.
Item 22.
Application seeking for
Yes. Mic call one. Apan upur ku jai paribeni.
direction to the opposite party number 3 to implement the order passed by the appellate authority.
The order
at annexer
2
page running page 14 and 15.
14,
Operating
15.
person and 15 years.
This is proceeding in mutation appeal.
Mutation appeal.
So you succeeded.
I have succeeded. Yes.
You succeeded.
My lord.
Okay, through annexure 2 series, page 14. Petitioner claims there has been allowing of mutation appeal 38 of 2020 by the order of the competent authority dated 9/6. Kete ko masya eta?
22 my lord.
22.
Order hela 22 re. 6/12/22. 6/12/2022 re order heichi.
6/12/22.
My lord.
Okay,
Order.
6/12/22. It is alleged even after making a request by annexure 3, there has been no correction of the record of right in terms of the appeal order. So this court finds strange in the attitude of the Tahsildar OP number so. In disposal of writ observes, in the event there is no challenge to order passed in MA 38 of 2020 arising out of MC 6620 of 19. The order of the appellate authority should be worked out by bringing out necessary record of right at least within a period of 1 month of the date of communication of order. Free copy of order. Yes.
Item 23.
May I please? My lord, the petitioners are very limited prayer. As per the prayer, my lord, and the reason of the prayer is also, as per the annexure, my lord, the prayer is that.
That miscase is still pending.
My lord, that is pending, my lord. My intervention petition is also that earlier at page 75, your lordship has.
You are an intervener there.
I am intervener there. They have committed the mistake that though the annexure 1, annexure 2, annexure 3 series are all everywhere in our ancestors' names, we are in the positions. They have not.
What is the dispute there?
Only dispute that we are claiming that we are possession of the land more than 100 years. So therefore, the district level committee should be considered because they have, after notice encroachment, they have.
Proceeding under which provision of law?
My lord, that is the provision of law is the, my lord, the Scheduled Tribes and Other Forest Dwellers Act Recognition Rights Act 2006 and rules framed thereunder.
Okay, in the event the proceeding is pending,
Lordship,
since he is likely to be affected, let the hearing also involve.
Here what has happened is the Gram Sabha is to institute the entire proceeding first. Then it will go to the district sub-level committee. Then it will go to the district level committee, which is the final authority. So now it is pending before the final authority.
He says it is pending before final.
Final authority, they have not approached
before.
before.
Place his case.
That intervention petition may be concerned, may be considered, your lordship.
Yes, all right.
My lord, I may be
At this
hard opportunity. My lord, I may be intervene petition along with all the petitioners. Opportunity should be given that will.
At the submission of respective counsel. From the submission, this court gathers petitioner appearance likely to be affected in the final outcome in miscase number 9/19 and miscase 50/19, claiming to be pending before collector cum chairman, district level committee, Kendrapada. Considering innocuous prayer and to find there is no multiplicity of litigation, this court is disposal of the data application observed in the event the proceeding is still pending before the collector cum chairman, district level committee. Through the aforesaid miscases, a lawful disposal to the intervention application at the instance of the petitioner should be given. In the process of considering the intervention application, the parties therein should also be afforded opportunity of hearing. With this observation, the petition stand disposed.
My lord, only one prayer that at the time of intervention, we are hurriedly 24 persons are filing. All the petitions as per the records and possessions, all the petitioners should be given opportunity.
Pardon?
Interveners, also the petitioner here, my lord. At the time of urgency and knowing, we are filing internal petition. At that time, we are only 24 persons. But now all the persons are.
No, only intervention, whichever intervention is pending, that will be directed to be considered. Can't be open now. If anybody else has a.
Yes, my lord.
Let them go. Let them go. You can't seek extension here.
My lord, my lord. We can have.
Item 24.
May I please, your lordships? May I please, your lordships? Here I have challenged the order under Annexure 1, my lord, that is a rounding plate 32, my lord, refusing to grant me extension time by the BDA, my lord. My lord, I have the lessee, the lease agreement.
What is this order, Annexure 1?
1, my lord, refusing to grant me extension of time, my lord, by the BDA for construction of the hotel, my lord, project, my lord.
It's an approved plan.
No, my lord, it is not approved plan.
May I summon my lord? He was allotted a plot by BDA to construct a hotel. The petitioner was given a piece of land to construct a hotel in the year 2020 and 2020. Till date, he has not undertaken construction. He says that
in spite of plan approval.
No, plan was not.
Plan because of you have not applied for. You have got the forest clearance and all
this. Is the question of extension?
My lord, here, my lord.
He wanted.
Maybe in the allotment there is a direction for constructing hotel within so and so period. Now you want to extend that.
Yes, because my lord, my predicament, my lord, it is also a circular of the government that due to COVID period, because lease was granted on 6/3/2020. That was for 3 years, my lord. But here, my lord, the COVID, my lord knows that from 20th of March, COVID started and it was continued for.
So why are you not considering that?
May I submit my lord one thing? He has not undertaken construction. COVID period has already gone 2 years.
Right, but COVID is a pandemic.
No, pandemic. There is no dispute on that.
Therefore, there is no question of undertaking any construction.
That is not the problem, my lord.
ଆପଣ ଯାହା plan କରିଥିବେ ସବୁ shattered କରିଗଲା. Therefore, ପୁଣି revalidating everything.
Yes, that is there.
So you have a time to.
I have got my humble. I'm not on that. My humble submission. In the meanwhile, 1 year past, he has not started construction. I have yesterday they sought the copy to me. I have already sent the copy to the BDA to take instruction in the matter. Today is holiday, tomorrow is holiday, day after tomorrow is holiday. So I will be able to.
So next Friday,
Next
Friday, but consider it for extension.
I understood my lord.
He wants to bring a business, employment, everything.
I applied before the BMC. Now the BMC approved plan is also on 11/4, my lord. That is an annex, my lord.
Because every plan is valid for a time period.
Yes, my lord.
So you have already violated the terms.
Yes, my lord.
Maybe there is a COVID reason.
Yes, my lord. But here, my lord, after that, my lord, I beg to submit, my lord.
Aji kahin kya real sir?
My lord.
କହୁଛନ୍ତି ସମୟ ନେବେ
ମତେ ଆଉ ଗୋଟେ ଏକ୍ସଟ୍ରା କପି ଦିଅନ୍ତୁ।
ଇଣ୍ଟ୍ରିମ୍ ଅର୍ଡର ଟା ଟିକେ ଥାଉ କାହିଁକି ନା
ଇଣ୍ଟ୍ରିମ୍ ଅର୍ଡର କଣ ହେବି?
ସେ ମାନେ ନେଇଯିବେ ପୁରା
ଓପନ୍ ଲ୍ୟାଣ୍ଡ ନୋ କନଷ୍ଟ୍ରକ୍ସନ।
ନାଇଁ ସେମାନେ କହିଛନ୍ତି
no construction
direct to hand over
open land. I think there would be no.
In the meantime, you will not take any coercive action.
Yes, not take any coercive action. Right, madam.
Had the Pradhan Learned Counsel appearing for the petitioner involving allotment of a land to the petitioner by the Development Authority brings to the notice of the court, even though there is no dispute that there is time stipulation in bringing in the hotel construction. The allotment made on 6/3/20.
6/3/20,
Allotment of the land being made on 6/3/20 and substantial period in the meantime suffered on account of the COVID pandemic. The construction could not be commenced. On the application for extension of time in completion of the project to give an outcome to the building plan already approved there.
No, it's already the building plan was approved, period expired, thereafter he applied and it was rejected.
Right. The Development Authority has come to reject the request for extension of time. Okay, this court find the case to be considered, direct issuing notice. Since the Dayanand Mahapatra Learned Counsel has the instruction to appear for Bhubaneswar Development Authority, 2 extra copies be served on Sri Mahapatra as undertaken by Monday.
Yes, ma'am.
Monday na aji dei debe.
Aji dei debe.
As undertaken by tomorrow, ghare dei diyan.
Ghare dei
By tomorrow. Sri Mahapatra seeks at least 7 days time for taking instruction. Place this matter on next Friday. Next Friday working day on 12th. In the meantime, there shall be no coercive action against the petitioner.
As per Annexure 1.
Persuade କରନ୍ତୁ client କୁ ହେଲା କାଇଁ ଆପଣ ନେଇକିରି ଆଉ ଗୋଟେ କାହାକୁ ଦେବେ ନା
construction କରିବ
ଶୁଣନ୍ତୁ ଆପଣଙ୍କ ହୁଏତ ଏହା ହେଇପାରେ you may impose some penalty.
Yes, yes. That is their clause. The clause is there.
ଦେବେ penalty ଦେଇକିରି
I am ready.
Binders is quite aware of the future of the dealt with this number of but so right.
Lest I am not taken as an advisor of Development Authority.
Must be.
So many matters ଆପଣ ଆମ ପରିବାରକୁ ଶୋଷି ସାରିଲେଣି ପ୍ରଥମେ ମୋ ବାପା ମାଇକ୍ ଆଗରେ
I have also paid for the lease out maybe.
Lease ବି ମୋ ପାଖରେ ଆସିପାରିବନି. Yes, Mr. Mishra, Annexure 1 is pending. Let us give direction for lawful disposal.
Lordship.
Considering innocuous prayer, finding Annexure 1 request at the instance of petitioner pending before Tahsildar Bhubaneswar OP number 1.
OP number 3, man. OP number 3.
Sorry, OP number 3 should be given a lawful disposal. This court has not expressed any opinion on merit in the claim of the petitioner. An independent decision should be shown at least within a period of 3 months of the date of communication of order, along with copy of writ.
Only small. Till then, no course of action.
Sorry. Yes, next.
Item 26.
At item 26 here, the state authorities, while taking up a development work, that is the renovation of a water body, have encroached upon the private land of the petitioner, and they have dug the entire land without taking demarcation, because had there been a demarcation, then the actual plot which was required to be developed would have come. That is, then the private petitioner approached the state authorities by representation. The BDO is the supervising authority and the junior engineer is the person in whose favor the work order is issued. This is immediately after that Madhusudan Setu in Cuttack CDA, which is connecting CDA sector 11 to Kaulapada Gram Panchayat. So there the 19 acre is being developed, but adjacent land which belongs to the petitioner are being destroyed. Only difficulty is we have applied through RTA information that how long this project will be taking up in the project. It is a 7 days project. The only grievance before the petitioner is that let the construction work go on, but leaving aside the private plots, kind of once there is a demarcation which is under the Gram Panchayat Act, before any project there has to be a demarcation. Let the demarcation be done and let the project go on.
Have you applied for a demarcation?
No, my lord, we have, if your lordship sees page 28.
Yes, Annexure 5.
Annexure 5, yes.
That is the entire grievance. We don't want the
Mr.
construction.
Mishra, since he has a grievance involving his private land,
My lords.
you go on with the construction,
Lordship.
but involve a demarcation exercise to find whether his land has been involved in the construction exercise.
My lords, I was seeking instruction from the BDO today,
You
in
will
fact.
take instruction.
I was seeking instruction. I sought instruction in the morning itself, morning hour, and he stated
What they
that
say?
he could not verify the records, but as far as his knowledge goes, there has been a demarcation proceeding that has been undertaken. So
Then I
lordship,
am posting it to Thursday.
my lords,
So you bring instruction in the meeting.
lordship.
This is a very serious issue. Suppose you are occupying, but it's a normal feature. People having 4 acres of land in enjoyment of 6 acres.
My lords.
The government land khali achi sadu madi modai dele. Seta koranti normally. So if a demarcation issue is already involved and find out if that involves the petitioner or not.
Lordship.
ଆପଣ ଆପଣଙ୍କ ମାପ କରିଦେଲେ ଚାଲିଗଲେ ସେ ଜାଣିନି ତାହେଲେ best course is let us involve a demarcation process, then you continue with your construction.
Lordship.
And in fact, state councils seeks time to take instruction as to whether before undertaking the construction involved wherein there is already involvement of a demarcation and again in the involvement of the petitioner or not. List this matter on next Friday as well. Next Friday. Instruction if any be obtained in the meantime.
But if only I make a submission that se kamo chalichi only jo plot guda achi setiki jodi till Friday se plot guda re details mu deichi joda amori plot joda akho pakho sethi construction.
Pardon?
Till Friday, if that construction should not affect the.
So the eparjanta ascertain heini whether they are in enjoyment of your land or not. Rather they say there is already a demarcation. From konosi government project demarcation nahi pillar nahi hobo nahi. So maybe there is already a demarcation process. Who knows? If it is behind your back,
that is
then you may be included. You also instruct them, if his land has not been touched, let there be status quo.
Lordship.
Pursue your client. I am not passing any order.
Lordship.
Yes.
Item 27.
A dispute regarding trademark. Now the authorities are complained about the such. It is pending under Annexure 5. My sole submission would be.
There is a CBI proceeding continuing.
Say those proceeding against that director to whom he has with me.
Then what is the cause of action here?
My prayer is that your lordship may look at not to give them the registration certificate. Now I have made the complaint before the registrars of company.
Then how can there be a mandamus in this regard?
My lord, my complaint is Annexure 5.
No, complaint cannot be entertained even. Complaint cannot be entertained. If you have a right over the property,
then go not for it, trademark. My name, my
trademark. Then go for appropriate proceeding.
That is registered company is now registering it. Your lordship may look at press 53.
Okay, the registration of trademark. Seta to more assignment we know. Registration of trademark.
Here a registration of company is approached not to give registration.
This is a matter under the Registration of Trademark Act. No,
it is register of companies. Company.
No, dispute before company, register company. But matter under which statute?
Matter is company registration. My company was registered.
Is a trademark registration?
Yes.
So there is a statute there operating the field.
You will also may look at page 53. My limited grievance.
No, let us first see where is the jurisdiction. What a trademark act ache. Yes. You have a complaint on trademark issue.
I have a complaint on the registration of the company.
That's okay. All right. It's a trademark issue or not?
He will not consider the trademark, my lord. He will consider whether the company will be registered under the Companies Act or not.
What is the ground there?
Their ground, your lordship may look at it. My company's name is Stevens.
So again, trademark comes in. So trademark comes in, trademark issue comes in, therefore come to trademark act. Jodi पढ़ी नांती समय नियंतु सोमवार दिन पढ़ी के आसुन ता भितरे dispute redressal mechanism अछि
सर आसु तो आरो
हां सोमवार आसु. Place this matter on Monday as the council wants to go through the provisions of the.
Your Lordship, may I be pardoned to mention in item 27, they have not
Just
served
1
the
minute, let me
copy.
complete this. Trademarks, the Trademarks Act 1999 and the rules 2002 therein. Yes, item 27, you are appearing.
My lords, I am appearing for Union of India respond opposite part number 2, my lords.
Name likhi dawo.
Mr. Nag is appearing on behalf of CBI, Your Lordship.
Mr.
Nag is here now. Your Lordship, a copy has not been served on us yet on the council for CBI, Your Lordship.
Where is
He's
there?
there.
Proper person.
Yes.
Where is there? Copy de diyo to Mr. Mishra. But
He left, Your Lordship. He left.
Next date.
As we have received the copy, my
We
lords,
have not
Mr.
received.
Nayak would receive a copy.
Mr. Nayak kahan pe appear karchandi?
Or CBI. Or if your lordship permits me, I will send a soft copy to my.
Nayak par gown kahin?
I'm sorry, your lordship.
Nayak ke gown show kale 5,000 cost. Mr. Nayak appearing, Sarthak Nayak appearing for CBI.
Therefore, I came.
It's not a dress code applying to the High Court practices.
Lordship,
This court imposes for disorderly appearance by a counsel.
Lordship, I was not supposed to appear. Therefore, I kept my.
And this court imposes cost of rupees 5,000 on Sri Nayak to be paid to Welfare Fund Bar Association. That's a general order nowadays. This may be my 105th order.
But Lordship, I was not supposed to
Therefore, you
appear.
can't escape. Sorry.
ମୁଁ ତ camera off କରି ଦେଇଥିଲି.
Next. Off କରି ସାରିବେ କରି ପାରିବେନି ଆଉ record ହେଇ ସାରିଲାଣି. These are all live.
ଡାକିଲେ ବୋଲି ମୁଁ ଆପଣ ଡାକିଲେ ବୋଲି ଖୋଜିଲେ ବୋଲି ମୁଁ ଆସିଲି. Therefore, I sent it.
ମୁଁ ଖୋଜିନି ଆଜ୍ଞା ଖୋଜିନି. Yes, next.
First time ଅଫିସ Lordship.
Deposit କରନ୍ତୁ next date ନହେଲେ ଆପଣଙ୍କୁ hearing debar କରାଯିବ. Yes, next.
Lordship, item 28, may I please?
Yes.
Lordship, the petitioner being aggrieved by the letter dated 3/11/2021 by opposite party under Annexure 3, Lordship, for non-renewal of his passport due to a pending criminal case and sought for direction.
Renewal of passport.
Lordship.
What are you challenging? Order Annexure 3.
Lordship.
Annexure 3, please come to page 32.
Lordship.
What is the direction there? Read the last part. From para 1.
Lordship.
Charged with criminal proceeding thereafter.
Lordship, he is involved in Padambadi PS case number 341 dated
Please read aloud.
Lordship, he is involved in Padambadi PS case number 341 dated 22/12/2018 under section 147, 148, 385, 294, 323, 336, 427, 109, 149 IPC. And the case is ended in CS white charge sheet number 160 dated 5/6/2019 under section 147, 148, 385, 294, 323, 336, 427, 109 IPC.
So and so. It is read like so and so. Okay, all right.
Lordship.
Then please send self-attested
Copies of the relevant documents only by post.
Then
the original of such document needs to be carried while visiting passport office between 10 AM to 2 PM. Only on all working days.
What is that date?
Lordship, 3/11/2021.
Okay. So he has fixed it to a day which has already expired. Now what is the development? After this, what have you done?
Lordship, as per my instruction, on the last date when he had appeared before the passport office, they said that all that this application has been closed. You need to apply afresh.
So you apply afresh. Maybe they are not satisfied because this cannot give a cause of action. This is only an indication there is a criminal case pending or number of criminal cases pending against you.
Subsequently,
so they are asking you to appear their office with proof. So you must have attended their office with proof. Thereafter, what happened? There may be rejection and maybe recommendation for applying a phrase. So why don't you apply a phrase?
Lordship,
why are you coming to High Court?
Lordship, the petitioner will be going for business trip.
That's right, business trip or luxury trip, but There is no passport now.
No, no.
So why are you not working out their direction? If you would have gone for a fresh application, it would have been considered. No. So there is no cause of action involving this order, Annexure 3. As you say, there is already a suggestion for bringing fresh application.
In the passport office, as per my client's instruction, they said you go before the honorable court. If you get an order,
For
then
that they will be saying, bring an order. There is no possibility of order on this. There is no possibility. What is your instruction if he has applied afresh? Because this has all happened in November 21. So what happened in the meantime? Have you applied fresh?
As per my instruction, he has not applied.
Then find what is the result. Can't be entertained.
Lordship may keep it to some other day. I will take instruction.
From the submission and from Annexure 3, it appears there is some sort of cause of action to the communication dated 3/11/21. Shri Prince Patnaik, Learned Counsel appearing for the petitioner may volunteer to submit. In the process of consideration, there has been asking to the petitioner to apply afresh. The Patnaik, however, has no instruction as to whether petitioners applied fresh and or any outcome to the communication at Annexure 3. Place the matter next Thursday, Asivo. Place the matter on next Thursday to enable Shri Patnaik to obtain update information. Yes.
Item 29.
May I please be noticed? It's pursuant to an auction notice of for sale of plots floated by the BDA. Lordship, can I turn to page 20?
Please renew your prayer submission.
Again, my lord, sir, there was a auction sale published by the BDA for sale of plots at Ghatikia and Netaji Subhas Enclave at Godakno. The petitioner, she participated for Ghatikia and bidded for plot number 221. Then she had, in order to participate in the proceedings, she deposited the participation fee of 5,000 and the EMD of 5 lakhs. Thereafter, nothing was communicated to her, my lords, as per the petitioner's case. And all on a sudden, she receives a letter at Annexure 3, page 34, my lords.
Yes.
Therein, 2 letters are referred to, one dated 25/7/2022 at page 34 of the Lordship's brief.
Read that.
25/7/2022 and 12/8/2022.
Read that.
My lords,
You are hereby informed.
You are hereby informed that for necessary consideration of provisional allotment of plot number 221 under Ghatikia in your favor, you are required to furnish the details of the deposit, if made by you towards the remaining 10% earnest money.
So what happened thereafter?
So thereafter, my lord, immediately, my lord, I rushed to the BDA office and I deposited this 19,60,000. Lord, if a lordship would kindly turn over the page on 13/10/2022, my lords, and I intimated them that I have already deposited.
Then what is the reason of cancellation?
The reason of cancellation, my lord, they say, if your lordship would kindly turn to page 36, they say they refer to this letter of 25/7/2022, and they say, Madam, your lordship may permit me to read through this. In inviting a reference to the subject cited above, I am directed to inform you that your candidature for allotment of plot number 221 under Ghatikia is hereby cancelled, and the earnest money of rupees 5 lakhs only.
What is the reason of cancel?
The reason of cancellation, my lord, according to what I ascertained, my lord, this particular deposit of 10% had to be made within a particular time, my lords.
So that was not deposited.
That was not deposited. My claim, my lord, is I was never received this letter dated 25/7/2022.
Okay, all right. Yes, all right. You
and
take
this
instruction as to
my
yes,
present
if
difficulty.
Even assuming there is some delay, an allotment cannot be taken away on delay account. Some interest may be loaded further.
So my humble contention that so far as that particular provision of auction is concerned, the brochure itself stipulated on and from the date of the receipt letter, you are to deposit the money within 1 month.
You have to prove.
Yes, I'll bring that counter. I will bring that in counter.
Demand is reached him.
Yes, I'll bring it. But fact remains, thereafter, if you want to extend the period,
the whole total 2 months can be extension can be given on payment of rent subject to approval of the vice chairman. For that you have to apply for. Thereafter there is no provision.
Their allegation is
They have not received
never
the letter.
received
They
at
have,
all.
they have not. That is what we
So
have
if
taken.
they have not received, you are apprised of the same by the perusal of the records even. Advise your client accordingly.
But here in this case, they say that 2 letters have been sent. I will find out whether this letter have been duly served or not.
Absolutely.
And also, Milord,
Then there is a bona fide action. If he has not received, come to know this subsequently, you must have deposited. Maybe it
I'll
is-
take instruction in that. I'll take instruction because
and my
yesterday night I got that copy. It's not practical.
Lordship, pardon me, Milord. My present difficulty, Milord, is now they have already
I am
advertised for.
granting protection. Right?
Much obliged.
Since I am entertaining, it has to be granted. In the meantime, there is no allotment of that.
No,
plot.
they have floated an advertisement and that the last date of advertising e-auction process again in respect of these 2 plots.
Don't allot in the meantime.
No, don't. Allotment process may continue. Sorry, auction process may continue. Because
That will
auction
create
process.
But there shall be no allotment.
E-auction
କାହିଁ ଆଉ କରିବେ defer କରିଦିଅନ୍ତୁ. Defer କରିଦିଅନ୍ତୁ. ଅଛି any allotment process initiated?
Yes, Milord. So I've given,
my
Milord,
learned friend has given a memo.
Milord. That was, I got it today
Okay,
itself.
this is notice 10-4.
Again,
What is that plot? Serial number?
serial number K1/221, Milord.
221.
There's the third plot number.
Had the submission of
Gatikia.
CORAM, learned counsel. Also involved the submission of Sri Mahapatra, who has the instruction to appear for Development Authority. The CORAM moves the application on the premises of non-service of the communication to the petitioner of the that is a communication annexure 3.
Well, annexure 3 was the.
Annexure 3.
Milord.
Non-communication of annexure 3.
Non-communication of letter dated 25/7/2022 and 12/8/2022.
Non-communication of letters referred to in annexure.
Referred to in.
Non-communication of the correspondences dated 25/7/22.
Referred to in.
As well as 12/8/22. But it is fairly submitted even in absence of that. And after coming to know the intention therein, petitioner visited the office of the Development Authority and made the required deposit. It is in the above view, the writ petition involved a challenge to the order of the authority by annexure 5 in cancelling the allotment. This court find Sri Mahapatra submits he has no instruction as to the communication of the correspondences dated 25/7/22 and 12/8/22, if any. And once instruction of the same issue, this court is inclined to issue notice. Extra copies be served on Sri Mahapatra, 2 extra copies at least, as undertaken by tomorrow. In the course of hearing, course of hearing, it has been brought to the notice of the court that there has been in the meantime issuing of a further notice in the auctioning of the number of plots, including the plot K-1/221 Ghatikya involved herein. Okay, keeping this in view, and as this court issuing notice, direct the Development Authority as an interim measure, direct the Development Authority to which may proceed pursuant to notice dated 10/4/23, but there shall be no allotment of the land bearing plot number K-1/221 in Ghatikya without leave of the court. Place the matter. କଣ କରିବା ଏବେ ଆଉ ଆଣିବା ନା ଛୁଟି ପରେ ଆଣିବା? ଛୁଟି ପରେ ଆସୁ।
ବାହାରକୁ କିଛି କହିବୁନି ଆଜ୍ଞା। ଏଇ ଯୋଉ 2ଟା ସେଠି ଥୁଆ ହେଇଛି ତାକୁ ଦେଖି ଏଇ ଯୋଉ 2ଟା ସେଠି ଥୁଆ ହେଇଛି ତାକୁ ଦେଖି ମୁଁ ଆଜ୍ଞା କିଛି କହିପାରୁନି।
A bar, my learned
Right,
friend,
right.
my lord, is correct.
I appreciate all right. Yes.
12 तारीख यदि subject to lordship's kind can be.
Asu, tale 4th of July. 4th of July.
May I submit my lords? Two plots, they are claiming 2 plus. In
One plot na?
One plot in this
would
case, and the
second case,
second one is the.
Second case re arata kariba.
So dita plot hala, aro dita plot auction process mein.
Arata kete number plot?
219.
219.
Hein?
219.
Setire achi, se notice re.
Again.
Okay, a plot re khali se jo achi, there shall be no further allotment of plot number. Rakha diya. K-1/219 in Ghatikya.
It is 219.
Same date ko asibo.
219. Second ta 219.
219 plot. First plot.
Again.
First plot in the list. Right.
I was just subject to lordship's kind consideration. My lords. I was praying if my learned friend would also take instructions and let them charge some interest and allot the plot. Because I have already
in that context, I'll take instruction. But fact remains, my lords, the power of the vice chairman lies only for 2 months. Thereafter, my lords, I will consider that and pass appropriate order. Let me come up with instruction.
No, for that purpose, Lord, may I pray?
Is there any restriction to the High Court in that way?
No, but that is exactly what I say.
For that limited purpose, may
I exactly what my lords may pass.
The timing plots are protected.
16 तारीख आसु ठीक है 16 तारीख आसु
16 रे आसु
16 रे जदी आसंता at least a limited instruction
आसु छुट्टी पर आसु छुट्टी पर आसु 16 तारीख भीतर नहीं परिबे
नहीं 16 तारीख at least जदी कोन मु तो पैसा देवा को राजी 19 लाख दे सारे
what my learned friend says, he is ready to pay money with interest.
All right, 18 तारीख आसु
18 at least a limited instruction ठीक नहीं होता
देखिए let him see what is his endeavor, what is the cooperation of the development authority. Now it is all ये सब बसिक खोल की बसती है आम केस चलची
in fact
तो ना बेसिक कथार्ता होबा
नहीं एटा बड़ा डैमेजिंग जो लाइव स्ट्रीमिंग टा बड़ा डैमेजिंग
लाइव
2930 दीटा को 18 तारीख रे ठीक आसु पदस दीटा को 18 तारीख रे
हां दीटा को 18 रे आसु
I
18 रे आसु
18
I may pardon university item 31 टा first contempt error
permitted to withdraw
नहीं first contempt error से
first contempt केते
item 31
first contempt disclose
let them serve a copy, my lords. Copy has not been served.
Okay, they the under
apply करा
how to withdrawal thila close कर
demobilize
34 टा close कर दियो हैला
31
then एटा को close करो ए जो modification टा कौन modification है who is there Vansi Vaishnav Das कौन एटा modification
in the last portion of the order dated 16/3/2023 in the process this court finds in both counts it has to be written the impugned order at annexure 1 my lord
कौन लिखा है annexure 1 लिखा है नहीं
no my lord annexure 8 लिखा है
okay annexure 1 is
the impugned order
all right that is disposed impugned order annexure 1
yes my lord
all right that is disposed बाकी केस काल के आसीबो
Monday
my lord I may pardon
expeditious hearing के फाइल करची ये छुट्टी पर को वाला yes recalling order की recalling order कौन recalling order के फाइल करची
my lord expeditious hearing my lord
expeditious hearing छुट्टी पर है हम मो रिटायरमेंट पूर्व किछि हे परियो नै
my lord
मो जा सुना अछि आगो सारे
my lord my humble submission my lord now if your lordship start date may be fixed my lord after vacation date may be fixed
no after retirement
no my lord no my lord it is
all right कर दियो 24th of July
my oblige
हला एटा भी गोला 35 गोला
my lord regarding recalling of the order my lord in that case I failed to apprise my lord the judgment passed by the honorable division court
हां ओके छुट्टी पर छुट्टी पर अप्राइज करिवे ये कंटेम्प्ट कोन 33 रे की अछन अमित ब्रोस
सेटा आसु आगे सोमवार दिन सेटा
ओके
ऑलरेडी कॉर्पस फाइल हिची
छाड़ दियो सोमवार आसो सोमवार नहीं नेक्स्ट फ्राइडे
आगे
item 33
2008 केस किए 38 ओल्ड मैटर किए से तेरे के आसुनांती नोटिस तो डिसमिस कर दियो देयर इज नो शोइंग ऑफ इंटरेस्ट केस पेंडिंग सिंस 2008
item 33 your lordship
just 1 minute हला dismiss for non prosecution is 33
I filed a miss case.
33 ଆସିବ ଆର ଶୁକ୍ରବାର ଆସିବ।
Monday.
शुक्रवार
ଆଜି ଫ୍ରାଇଡେ ସେ ପୁଣି ଶୁକ୍ରବାର ଆସିବ।
ଆଜ୍ଞା।
I may pardon my lord. The parted matter item 41 my lord. Not reached today.
ସେଟା ସୋମବାର ଆସିବ ସେଇ ଯୋଉ ପାର୍ଟେଡ ମ୍ୟାଟର କି ସେ ଏଇ ଯୋଉ ଯେତିକି ହିୟରିଂ ରହିଗଲାନି ଏଇଥିରେ କିଛି ଶୁଣ କୋଉ ଆଇଟମ କହୁଛନ୍ତି ଆପଣ?
Item 41 my lord. It was parted
41
my lord. Admission 41.
41 41 ଟା ହାର୍ଡ ଇନ ପାର୍ଟ ଥିଲା ବୁଝିଲ କି? ସୋ ପାର୍ଟେଡ ମ୍ୟାଟର ଟା ସୋମବାର ଦିନ ଆସିବ।
Item
23 ମ୍ୟାଟର ଯୋଉଡାକ ଅଛି ସବୁ ପଳେଇବ ଆଫ୍ଟର ଭେକେସନ।
No, Lordship, item 42, I am the election petition in the court below. Here in the opposite part number 1, the matter infructuous. My lord has granted stay operation of order dated 7/2/2023. On 7/2/2023, land trial court directed to start evidence side of the witnesses.
What do you say? This matter has gone infructuous.
Infructuous, already witnesses already examined.
ଆସି ତ ମନା କରୁଛୁ।
My lord,
ତାହେଲେ ସୋମବାର ଆସୁ ଦେଖିବା।
yes.
ହଁ ସୋମବାର ଆସୁ।
Counter
କଣ ଏଥିରେ ହବ? ଇଲେକ୍ସନ ମ୍ୟାଟରରେ
file କରିଛନ୍ତି।
ଫୋପାଡ଼ି ଦିଅନ୍ତୁ ଡଷ୍ଟବିନରେ। Statutory proceeding, why do you insist? ଯେ ତାଙ୍କର ପଇସା ନେବେ ବୋଲି ଗୋଟେ କାଉଣ୍ଟର ଫାଇଲ କରିଦେଲେ।
Counter କଲୁ 12 receive କଲେନି।
ଦେଖିବା।
ये lordship पे pardon.
ये 43 और 44 ये आफ्टर वेकेशन है ना। इंट्रीम ऑर्डर ଥିଲେ एक्सटेंड हो।
ये lordship पे pardon 29-30 रे urgent side effect को।
अर्जेंट ଆଜି ହବନି ଆଜି।
ना काली सोमवार हो।
ଆପଣ ଆର ସାଇଡ ର କାଉନସିଲ ଥିଲେ ମୁଁ ଅର୍ଡର
ସିଏ ଚାହୁଁଛନ୍ତି ଗୋଟେ
why are you apprehensive?
ଆଜ୍ଞା ନା କପି ଚାହୁଁଛନ୍ତି।
ସିଏ ଅବିକା ଯାଇ ବାହାରେ ଫୋନ କରିବେ ଏୟା ହେଲାଣି ବୋଲି କାହିଁ ବ୍ୟସ୍ତ ହଉଛନ୍ତି?
My lord, item 37 my lord.
This is the order passed. Sunday intervening.
ना ठीक।
So you
My lord, item 37 my lord.
37 not pressed.
No my lord, my lord, may kindly list it on Monday or Tuesday.
37 ଟା କଣ ମ୍ୟାଟର? ହଁ 37 ଟା ହେଲା ପରେ ଆସିବ ନେକ୍ସଟ ୱିକ୍ ଆସିବ।
My lord, may kindly list it on Monday or Tuesday.